broken maker, where crimes are baked in every show. Mysteries rise and truth unfolding. Brandi said it's time to go. We stand in time to go. Whistling through this battering news, makes this story solving the lies. In this kitchen, secrets are broken, with a spark in our eyes. In the broken baker's kitchen, the secrets crumble like sunrise. We'll sift through clues to find the rules, with a spark in our eyes. The broken rise. Broken rise. Welcome to the broken baker. Get ready. Let's go.
Good morning, good evening, good afternoon, whoever you are, wherever you are, what if any you are, and welcome to this Sunday panel show about the Karen Read case. And this is the third one, so I'm bringing back some old names and some new ones. First of all, my dear co-host, Mr. Valhalla.
How we doing today, y'all? It's been a busy
And
week. It's been a busy week.
Yeah, hopefully it ends tomorrow.
Hopefully.
Mike, yeah, right
Mike, how
when
we
you're
doing?
drinking. That was
Drinking some water. Hi, guys.
How you
Good to
doing?
see you,
Hello,
buddy.
Baker.
Good to see you.
Yeah, of course I'm drinking water. I'm getting ready for the show.
I'm drinking
Thank you
water.
for having
you're
me
going-
back.
You're going live again at 8:30.
Yes. We have a big show. We have Bederow and we have another Massachusetts ADA. We have two ADAs, former ADAs on. Shannon McMahon from Massachusetts and attorney Mark Bederow, who's on tonight with you.
Outstanding.
Talking about Mark Bederow. Can you
Speak
get,
of the
by the
devil.
way, can you get me in contact with Shane McMahon?
Oh, yeah.
No, that's not the name you mentioned.
Not that Shane McMahon.
Wrestling
Not
joke.
that Shane
Wrestling
McMahon.
joke. Don't care. Hey, Mark.
How are
Welcome
you?
back.
Thank you.
Oh, fine. And ready to figure out what, if any, movie deals you are having. Because apparently they are throwing them away right now.
Yeah, if they're giving them out like candy, they haven't called me yet, so I'm right here.
It's going to be
Horrible.
amazing.
Horrible.
I think I want a young Chris Farley to play me.
Again, dibs on Jack Black.
And
I'll take Clooney or Charlie Sheen for me.
Ooh, Charlie Sheen would be good. That'd be
Tiger
good.
Juice, Tiger Blood, whatever it was he was on.
Tiger Blood.
Talking about being on, the only one I think streams more than me, Miss Brandi.
Hello,
Welcome back.
hello. I want Reese Witherspoon to play me.
Oh, that's good.
Right?
That's good.
I
like
think we both got like that southern blonde, we seem nice, but we're really, sassy. I like that.
I like
That's what I want.
And for the first time on the channel, and I think for a few of you, the first time you're meeting her, the wonderful Andrea Burkhart. Welcome on my show. And you're who's going to play you?
Probably Anne Hathaway. I get Princess Diaries comments from time to time.
I like that. I could see that.
I could see Hillary Swank almost too.
I would take that. I would take
yeah.
that. Absolutely, $1 Million Baby. That's my girl right there. That's
You're a
my girl.
boxer too, right?
Yes, I am. Yes, I
Yeah.
am.
Look at you. I like
There
it.
you go.
I
I like that we're casting our own stuff. Like this is this. We could have a panel of just this, like just casting the movie for our parts and everybody else's.
Well, I'm thinking if LG is getting a movie about herself, someone should move to Denmark and make a movie about me, because
No,
that woman.
I've been getting the calls, but I am like, oh wow, they want me, and then it's always they want my guest list. They want all my contacts. They want.
Yeah.
Yeah.
Me,
It
it's they
works,
want free content for their documentary.
And
Come
then
please
they're
help us
like,
out for free so we
Yeah.
can sell it to Netflix or whatever.
But I'll help them because maybe they'll put me in for 2 minutes.
It'd be good, right? Just get your face and your name out there. It's always
That's
a win.
it, right? I mean,
See, we learned a hard lesson with Depp v. Heard. I look very, very askance at the documentary producers. You
I
just
know.
never know what the slant is going to be.
that's what keeps me up at night, actually, Andrea. How do you deal with that? You not knowing like how they're gonna
Well, if the mainstream
Say no a lot.
mainstream
I
headlines
deal
on
with
this
it by saying no a lot.
one- If the mainstream headlines are any indication of what the Netflix documentary is going to be, I would maybe avoid it too. Actually,
I saw
Buyer
Court
beware.
TV was running with a Kion or whatever they're called. Experts
Chiron.
confirm he was hit by a car.
yeah.
Trooper Paul is an expert. So am I. Because I can also put in stuff in an equation and say, yeah, it makes sense now.
He didn't know the equation though.
He didn't know the third law of conservation of momentum.
he didn't even know
He
the
didn't
form.
even know that. Like, let alone not knowing the formula. He didn't know the concept.
Oh, bless him.
What course
Well-
are we in? That's what it felt like with him. It was like he didn't even know what class he was in. He was like in the wrong class that day.
Like, what do you mean by physics stuff?
Yeah. Like, I thought this was algebra.
Sure.
Actually, Nick has a very poignant question for that. I have heard that exculpatory evidence presented to the prosecution months before the trial does count in Massachusetts. If the prosecutor can argue against the law of physics, can you confirm? Mark,
Based on
you're the
how this
local
is
lawyer.
going, confirm. Yeah. Yeah. I mean, there's at least one science denier, right? At least so far. So somebody's troubled by it for some reason, which doesn't make a hell of a lot of sense, and believes in the Trooper Paul theory of gobbledygook. So who knows?
Right? I don't get it.
I
For me,
don't-
that was the game changer. I had said I was going to stay open until the very end. I wanted to hear everything there was about everything, and then at the very end, that's the bombshell. That's like, you know, the two that are the independents that were not hired by either side, that are, instead of their answer being, well, it just is, or it just did, or and stuff. Instead of any of that, there was like, okay, well, you know, this, and then you like insert all this smart talk. And for me, that was, you know, the physics and the science and the explanations and why they thought this and why all of these other things didn't affect that. Like, well, did you know his DNA was there? No, it doesn't matter. It doesn't change physics. Somebody's DNA being there doesn't change physics. And for me, that was like, how could you have reasonable doubt, or how could you, you know, not have reasonable doubt after that? So, but I guess my
Well,
advice-
Agreed.
I have one. Now, granted, we have to recognize hindsight is always 20/20, right? And so anybody can look back and pick apart, you know, things in retrospect. In hindsight, considering where we are and the fact that at least one person on the jury is clearly struggling with concepts like reasonable doubt and so forth, I do look back on the Crash Daddy testimony, and I wonder in hindsight if it was potentially problematic that this entire new theory got introduced that late in the game. This theory that potentially John could have thrown the glass into the taillight. And that would have been consistent with the damage to the taillight that, you know, as it was photographed in the Canton Sallyport garage. I have to feel, just given the question from the jury about the CERT report, about just the inherent challenge I think the defense has always had with this case, which is the difficulty in convincing people of a frame-up, because nobody wants to believe that. That is a scary thing to believe about your own police department. I have to wonder if that potentially created an opportunity, is maybe the best way to put it, for somebody who is already not really inclined to acquit, somebody who has that suspicious, judgmental kind of nature. I don't like Karen. I don't like her explanation. I don't like her defense. I think I don't like her texts with Higgins. I think she did something wrong here and just doesn't want to let that go. I have to wonder if that late in the game testimony created a potential opportunity, a foothold for a position like that, because it gives them something to seize on as far as a mechanism of how this could have happened, that explains why the taillight pieces would be at the scene. They don't then have to accept a theory that the taillight pieces were planted after the fact.
Yeah.
But
I don't know. That's
I actually, now we have been sitting for a week thinking about this. I don't even know why they went with that thrown glass theory, because it muddles the waters. It's, the only thing he should say was, no way scientifically was that body hit by a car, and no damage to that car in any way shows a body hit. I think it was cool to talk about a cannon, and you can see how happy Crash Daddy was. And when Crash Daddy smiled, so does on the
So
bed.
does the world.
And the world
Yeah.
smiled with him.
It was, but I don't know if it helped. It's one of those
I think-
things where you're sitting at home and thinking, "Oh, this is really good evidence," but it just
none of
It's,
this.
it's
I'm sorry. I just because none of this should have mattered for the simple reason they don't have the burden of proof. And
Yeah.
if you look at reasonable
Mhm.
doubt, the jury doesn't have to believe it's this or that. The bottom line is, if the car crash could not have caused the injury due to the damage on the car and the body, is that reasonable doubt? Yes. And then if you go down the line, and then you have 45 pieces of taillight that are lying there. Is it reasonable that could have been planted? Yes. And I think, to me, the what you call the crash daddies, the ARCA guys, could have segued very nicely as a lead-in the summation to the argument about Proctor and planting the evidence. Because if you already have the car accident can't be the cause, you've already got them thinking there's probably reasonable doubt, and all of a sudden it leads really nicely into
Where did it come from?
the cover up, and now it makes sense. And then from there you go, well, look at Proctor. Does he have that gene in him to do it? Well, look at his
Yeah.
text messages. Look at what he said. And I know they only had an hour to do it. What I just wonder why they didn't start with the ARCA stuff as a natural segue into the cover up.
And Thunder Queen asked a question. I think a lot of us is thinking, do you think the jury is playing detective in there? I thought that when we got the question about the CERT report. Are they trying to figure out?
I don't think so. I think they know where they stand. I think that we're really close to some kind of an acquittal. I'm feeling more confident with what Mark's been saying all along. I really do. I think she's going to be acquitted. I really feel like that. On the, like, maybe not on one of those lesser charges. Maybe that's, we got a tip on this today. Like, and it just makes sense to me. What if they're just hung up on one of the lesser charges? What if they've already acquitted her on that top charge? I mean,
Well, that could be, but that would go more to intent, which is, pretty weak. I mean, the whole Aruba, anger, I hate you, you're a pervert, all that stuff, whatever that means. But if they're stuck on any charge, then if we're thinking about this logically, which they may not be, juries are juries, who the hell knows what's going on in there. But again, the seminal issue is the car accident. And if there's any doubt that she struck him to cause his bodily harm, then it has to be an acquittal or a conviction on something. And then, because it's not the car accident. And to me, when they were looking for the non-existent CERT report, that at least is something that sounds to me like in the right area. When did they find it? Who found it? Where was it? How could it be there? That sounded like they're processing the right analysis, and they haven't had any substantive questions since then, which, I mean, we're reading tea leaves again. We shouldn't do this, but I guess we're here, so we should. It sounds to me like they're still debating the car accident, and maybe they, left it, went to intent and acquitted on something. But if they're still debating the car accident, then I still think there's some degree of optimism, maybe less than there might have been 3 days ago, for an all-out acquittal. And, you know, somebody's troubled by it, obviously, but it seems to me just to be so basic with the concept of reasonable doubt that it's hard for me to fathom this still doesn't end in an acquittal. I know a lot of people think I have three heads when I say that, but it's so overwhelming in light of the ARCA witnesses for reasonable doubt. It's just remarkable that it could be anything but an acquittal.
I thought about the whole CERT team thing when they were asking to see a CERT report. I thought about that too, because one of the things that, as it relates to the whole glass throwing thing, because the glass throwing thing is something that I had mentioned, you know, like a few months ago as a possibility, because it was one of the things I was thinking, like, maybe if he threw the glass, and because I kept trying to think, how does a glass or a taillight bust like that, you know? And so when they brought that up, I was like, oh, it's being Crash Daddy, or, you know, like, we just think alike, you know?
Mind meld.
Right. But that was one of the things I thought. And then when they were asking to see the CERT report, I was thinking, okay, maybe if they're, you know, they had said that the very first piece of taillight was found at 5:45, and I put this in the most recent podcast episode that I put out yesterday, because I went back and checked the timeframes on a few things. The first piece was found at 5:45, and if you remember that picture that they showed of that taillight piece, it's like just sitting on top of the snow. And he said that he had them lay it on top of the snow to memorialize where it was, but that it had come out. So that was at 5:45. He came. That was what's his name? Tully. He came from Canton Police Department to Fairview at that time. Like, when he came, he didn't come from home. He came from Canton Police Department, and he said he went to the scene about 5:30, which is the same time that the car was getting there. And then he shows up, and then all of a sudden, then there's a piece, and it's on top of the snow, and they take a picture of it. That goes toward more of defense theory as opposed to, you know, just digging it out and finding it. So I had wondered too if maybe they were trying to look at some of the CERT notes or CERT, you know, reports or anything like that to see if, you know, to check some of those timeframes, because I know that time right there is one of the most crucial times that they have to be able to explain how they got taillight there. And I mean, that's a pretty logical explanation. If that's, you know, if I was going to argue for that, that's what I would argue.
There's also the glass, or the plastic, whatever it is, the 45 pieces. There's too much of a spread out. I mean, if the guy threw a cocktail glass and shattered a taillight into 45 pieces, the problem is it's all over the lawn, all over the place. That strikes me as just impossible.
Yeah.
That was a big question that I had throughout the forensic evidence in the cases. Where's the rest of the glass?
Yeah.
Where's the rest of the glass? It's not on the bumper. You know, there's this strange just configuration of evidence that's kind of supposed to make it look like that. But if the bumper glass doesn't match the glass and the rest of the glass is never recovered, where is the rest of the glass?
Yeah.
If only they had looked in the house.
If only.
Oh, wow.
Right?
I just
Gee, I
can't
wonder
help
where a glass would come from.
but think you have one of two situations. You have a juror who's struggling, who ultimately gets turned, and this has, you know, the happy ending for the defense, or you have the dreaded kook on the jury, and, you know, it happens. And I mean, I said this somewhere else the other night, but when I was trained as a young prosecutor in Manhattan by a genius in trial practice, his whole thing was, when you pick a jury, two things only, nothing else matters: brainwash and get rid of the kooks. And, you know, do whatever you can to just try to identify kooks. Don't worry so much about what they do for a living, what they look, just kooks are kooks. And it could be that there's a kook for whatever reason. Hopefully that's not. It's just somebody struggling, which I'd have to think it is, because these guys clearly know how to pick a jury and spent a lot of time researching. And look, I'm sure they probably even had a consultant, given what they're spending on everything else. I mean, we'll have to see. But I still think this may turn out with a verdict.
Well, I'm curious to see. I'm sure you've experienced this, Mark. I've experienced it, and a lot of folks have noticed this. There was, I think, a fairly recent trial that Judge Cannoni did. I don't remember the name of it right now off the top of my hand, but a situation where similarly a hung jury, she sent the jury back multiple times, I think 3 times, and then the final time they came back with a guilty verdict. And that is an unfortunate tendency, at least in my experience, when you continue to hold them and sort of push them to reach a compromise, even if they don't necessarily want to, that often that goes in the favor of conviction. I am not so sure that is the case that we have here, and I do wonder. It seems likely that it would be the opposite, and so the more that Judge Cannoni would push them into, somebody give up. Give up your fight here and just give us a verdict, that would produce a not guilty. And so given that, I do wonder, are we going to see Judge Cannoni send this jury back multiple times, or would she accept the mistrial?
Mike, we talked about this the other night, that normally when you push, it invariably leads to convict, usually. But this is, I think, the exact opposite, because the evidence so much favors an acquittal as opposed, in terms of a unanimous verdict, than a conviction. And clearly we don't know what the count is in there, but it just has to feel like it's 11-1, 10-2 to acquit, just because it's so obviously a defense case. And so I agree that if somebody's leaning on the fence, that it's got to be leaning that way, and the longer it goes, that would favor an acquittal. Also, as was brought up the other night, if somebody's hanging on, preventing an acquittal, that's a lot easier to change your vote than the opposite, where if you're the one that's literally delivering the hangman's noose on someone's life in the balance. So, again, assuming it's not a kook, all disclaimers apply, I still feel they may do it.
Well,
we had the verdict form.
The verdict form is such a massive problem. The verdict form is such a massive problem on count 2. This is something that I saw as soon as I saw this verdict form, I immediately saw what the problem was going to be. And it's that they don't have the option clearly on this form to acquit of the greaters and then potentially hang on the lessers. So if the problem is they're looking at this voluntary manslaughter charge, and they decide flat out, no, they don't think she did something reckless. They work their way down through the list. That would pretty much take involuntary manslaughter off of the list as well. They get down to that motor vehicle homicide, and it's just a negligence standard. Did she do something the equivalent of like running a red light? That level of culpability. And so if somebody is thinking, although I don't see how they get there, but if somebody is thinking, yes, she did hit him, but maybe it was just an accident. Maybe she just was going too fast. Maybe it was too snowy. Whatever. Somebody could have this idea in their head, but you can't get the full jury behind that. As a matter of double jeopardy, if they have acquitted on the graders, you cannot retry her on any of those. Double jeopardy attaches, and it is barred, but they can retry on anything that the jury hangs on. So I have a massive problem with this verdict form on count 2, because it makes the not guilty all or nothing. You either acquit her of everything or you acquit her of nothing. And so it doesn't hold open that possibility that, potentially they could reach verdicts on some of those graders and then just hang on the lesser offense. And there's no way for this verdict form to reflect that.
And the scary thing is, and I know, Andrea, you and me, this is like really getting in the weeds on the law stuff for verdict sheet and double jeopardy. But the scary thing is the judge's response when this was first brought up, which is, this is how we do it on every case.
This is how we do it.
And I'm sorry, Mr. Hollywood guy, but you're not going to come in here and disrupt the system, when the reality is, I agree with you 100%. How do you know what counts are acquitted or not? And now, you run the risk of trying to retry her for something that they meant to acquit. You don't know. And the judge's response is, this is how we do it. So who cares? And that's shocking.
But the problem is,
I hate to break it to Judge Cannoni, but the forms can be wrong. The form instructions can be wrong. These things do get struck down from time to time as being incorrect. Like there's nothing magical about them because they're a form. They're subject to legal challenges just like anything else.
Dave went on the Massachusetts website, and they took out that instruction that clearly states, if you don't find her guilty of it and leave it blank, you find her not guilty. There's an explanation that shows that if it's a blank, she's not guilty in that.
Yeah.
Which
And
they
it wasn't on
didn't
that
put
form,
on this one. And Brandon,
Very
I think
bizarre.
the demographic is it 6'6"? I believe it is. The foreman is a male. I believe it's 6'6".
He's juror number 1 is a guy. She did say, "Sir, will you be the foreman?" But
Yeah, and is it custom in Massachusetts that the judge picks the foreman before they draw the alternates?
I saw Larry
Juror
Ford,
number
the
1.
UI guy, said that he had a couple people reach out to him from that area, and they chose their own foreman.
my understanding is that it's the judge, but before you get too conspiratorial about this, and I mean, there's plenty to complain about her, picking juror number 1 is as unimpressive a scandal as there is, because in New York, juror number 1 is the foreperson by law. And even if she has the power to pick and she says, look, you're the guy sitting in seat number 1, sorry, will you do it? I don't know if she does that in every case. I don't know if in the last case she picks someone else, but it seems to me that's probably over analytical, because the other thing is, what does the foreperson do? All they do is sign the notes, and they're the lucky bastard who has to start the deliberation and say, what do you want to talk about? I mean, they don't have any real power. I think people read into the foreperson. They're just a vessel to communicate a note to the judge more than anything else.
Yeah, and there's so many things, and this is the worst thing about when deliberation goes on for so long. Both sides see all the conspiracies. Well, the foreman is a former cop, and he knows all the cops, so he's pointing them in one direction. No, the foreman is a former cop who hates all other cops, so he's trying the other way.
Do we even know if that's true? If he's the one?
No.
Yeah.
And they both picked the cop. So
the defense also picked this jury. That's an important thing to remember. And while it's true that sometimes you are choosing the best of bad options when it comes to a jury, they passed on them for cause.
Yeah.
Or at least if they did challenge anybody for cause and that was overruled, they've preserved it for appeal, and that's all you can do in that situation.
And also, if he's juror number 1, then if you're earlier in the panel, you're more subject to be stricken with a peremptory just by the nature of how many peremptories you have, as opposed to sometimes you get stuck in the back if you've burned all your peremptories. The other side will use 3 in a row to guarantee they get somebody really good. So my point is, if you're juror number 1, you just got picked early, then nobody could strike you for cause, as Andrea said, and both sides with a full basket of peremptories passed. So he appears to pass muster for both sides. And if the defense put on a cop knowing that their defense is that the cops in this case are scumbags, they must have been comfortable that this guy is an honest, legitimate cop and is going to be very critical of the Proctors and Buchanans of the world. So I wouldn't read into this guy without knowing more as the so-called kook or bad guy, although he could be. But I mean, we're just totally guessing at this. But they wanted him. Both sides were comfortable with this guy sitting.
So
I'm not worried about it.
While we're on the conspiratorial aspect, the nod, I think we should probably address this whole thing, right? At the very end.
Yeah, I saw people
dismiss.
posting about that. Yeah.
So I saw it in real time, right? And basically what happened is when she called the jury in and released them for the weekend, Paul O'Keefe is looking in one direction. He purses his lips, and it looks like he gives a very, very faint little nod of the head. Now, my conspiracy brain immediately started going, what was that about? But in reality, I should say, it could have been anything, right? It could have just been he saw something on somebody's face that made him happy, and it was a subconscious little, okay, good. You know? My immediate response was, oh, who does he know on the jury? But
I'm not buying
it's a bridge too far for me.
I just think that we shouldn't even focus on him at all. It's just like, I mean, Like, why? I mean, he's not doing anything.
I
agree
think
with
that
Mike.
everything has been so crazy around this case that I think that now, and with everybody waiting on a verdict, I think that everybody is just like, minds are just going. And I think that a lot of things that you would normally not think twice about, I think that people are not only thinking twice about, but just, honing, like full on diving in on.
We need to breathe. Everyone needs to have a breath.
Right.
Monday's coming. Tomorrow's coming. It's going to be, I think, a good day. We'll see.
Yeah, but this is the worst part. Paul O'Keefe does look like a weird dude. But the problem is we're sitting here and all of us is trying to fill out. Some of you are smarter than me, so you don't go live all the time and follow it live. But me and Brandi has been trucking through it every single hour of it. And at some point you begin to read Twitter and Discord and your chat, and everyone is sitting there saying, "Oh, Turtle Boy said that girl was crying, so they're forcing her to something." Yeah, but we don't know what they're forcing her to.
Stressful. I mean, that could mean nothing other than I thought we were close, we're not done. One last thing about Paul O'Keefe too. He's in the most unfortunate seat in the entire courtroom. The camera by default is literally on him more than any other individual in the courtroom. So if he picks his nose, you're going to see it. If he nods for whatever reason, you're going to see it. And he's just, in that seat.
I have to say, it's not on his face the entire time. I have seen more people than I want to see.
No, it doesn't appear to be.
Oh, and this is another one everyone is talking about. No, you can't have the witness transcripts read back to them, as far as I understand, because you have your notes. She instructs you, you take your notes, and you rely on your memory and your notes. They can't go back and replay the trial. The trial is done.
Correct.
This is a disaster. So they would never get the transcripts. They would get readback, which apparently we're being told by Massachusetts lawyers is not a thing. And this is absolutely bonkers. So they're given notebooks and allowed to take notes, but now you're relying on 12 jurors to diligently take notes, not zone out, record accurately. Then they're being told that these are just items to refresh their own recollection, that they're not evidence and they're not to be shared. But what happens, and this happens in cases, I mean, people have, New York, because you get readback, so you know what they're thinking when they want it. You could have two jurors who took notes but didn't write the same thing, arguing about what the evidence is. It could be on a very big point related to something involving these ARCA witnesses, and they're not even allowed to write a note to say, can we please have the direct and cross of Dr. Wolf as it relates to the glass on the taillight? And the answer, apparently, if they were going to do that, is no, you can't. This is so ridiculous and could be the difference between an acquittal and a hung jury if they don't know.
We actually...
We have a similar practice in Washington. It is discretionary with the judge. They have the option to do it, but it is highly disfavored. There's an instruction, a cautionary instruction that they're required to give if they do decide to read back a portion of the testimony. It doesn't make much sense to me at all, frankly. And the justification for it is supposedly that it's going to draw too much attention to just that one particular thing. And that could create a false impression of the evidence because you're taking it out of context. You're not looking at it as a whole, and you're focusing on that to the exclusion of all the other things, the exhibits and so forth that are available to help you decide the case. To me, this is just kind of nonsense because you have the exhibits back there in the jury room. Nothing is preventing the jury from being able to watch the taillight videos over and over and over again. If that's what they think is important, then yes, it should be available to them to go in and clarify those types of details for the exact reason that Mark is saying. You don't know who's paid attention to what. Every one of us who is streaming this trial consistently every day, we had our lally-by moments. Okay, we hit our lulls where just being able to kind of keep your eyes open and track what is being said was excruciating. And the example I would give is it was at the very end of one of the days when Trooper Buchanan was testifying, when they were watching through those videos from the CF McCarthy and giving us the timestamp where they would go here and Sergeant Buchanan would say, oh, and at this point she dropped a shot glass. If you were not paying attention, quite closely while this was happening, you wouldn't be aware that like 99% of the things that he was saying were happening on the video were not happening on the video. Like we are watching them with our own eyes, and it is not happening. And so a juror who's like in a lull, they may just have heard that testimony. They've taken that for granted. And that's the kind of place where, yes, it would be very helpful for them to be able to go back and get that testimony. Yeah. When is he talking about? Let's look at that on the video. Let's double check it. And they're not allowed to do that under the Massachusetts rules.
Now, the Mass rules, from my understanding, it's allowed. Has to be unanimous. The jury has to unanimously request it. But the judge, if you look at this judge, she hasn't let them know that. And she's actually instructed them kind of the opposite of that you have no more. We're not giving you anything else.
They don't even know what they can do.
So it's like de facto, they could do it, but they can't. This
is the first time I would ever say like New York knows what they're doing. This is kind of a first, but I've been trying cases in New York for 25 years. Every single jury instruction right before they go deliberate, every case, they are told, if you want readback, you are entitled to it. And you just simply have to send a note, okay, if that's what the jury wants collectively. And you need to tell us what witness. Do you want direct? Do you want cross? Do you want both? And if it's related to a specific topic, you have to say so. And to Andrea, to address, the so-called policy against it, never has it been a problem where there are 27 notes and it's just constant. I mean, there are times where you have to sit and parse through the transcript. Does this respond to what they want? But, you use Buchanan as an example about what people may remember or don't. But remember his testimony getting twisted around about the inverted video and whether that was him or not and who was driving. I mean, this is important stuff. And they may not remember. There could be timelines. There could be positions that are different where if there's a disagreement, they could say, you know what, let's go to the transcript. And then they listen diligently. You can see them. And if they have their notepads, they could be writing furiously. It's just unbelievable that they wouldn't allow this. And even if it is allowed in certain instances, Mike, like the way you were saying, you have to tell them in advance. They don't even know what they're entitled to do or not. And it's
no, they've been told they can't. They've been told they're not going to get it.
Right.
Basically take your notes and that's all you're going to get.
Right. You should rely on your own notes, like you said, when everyone's half asleep for half this trial, for what's happening, rather than just have a court reporter read actual evidence. It's astoundingly dumb.
And with this super chat from Stephanie, this is a 2-month trial. It's not that
I can't remember.
We started at 8:00 and we're going into deliberate at 2. In Denmark, when I do duty, we have a lot of time between days. We don't run them consecutive most times. We are always given a transcript of the last day in court, where everything is written down, what happens, and we can read through it. And you have your own notes, and you have what the judge took down and the audio. So we can read all of it, so we know, okay, yeah, that's what was talked about.
But the irony is, she gave them a copy of her jury instructions because, in case you can't remember, which when most people would say, like in New York, you don't get the jury instructions.
That is funny.
And this was a big thing in the Trump trial because the charges were really convoluted about, what was the underlying crime for falsifying business records. But they're told, if you have a question, come back. And rather than have them read the jury instructions and argue amongst themselves, what the hell does this mean? Again, this is the second time I'll say New York maybe has a better way. If there's a question, you go to the judge who presumably knows the law, and she tells the jury, this is how I'm going to answer your question. This is the law. So she won't let them have the facts, but she gives them the law, which only increases the risk that these convoluted jury instructions are going to be misinterpreted because juror 1 and juror number 4 are going to have a different impression on what the hell it all means anyway, but we don't have to ask the judge because she gave us the instructions. This is like the Bizarro trial on every level.
Mark, I'm interested in your take on just the jury and the jury instructions as a whole, because when I was reading through these, and I looked through the forums, and I obviously watched and listened to her read through them, these are some of the most verbose instructions I think I have ever heard in my life. Just a painstaking amount of detail, kind of far beyond the point of it being helpful. You start to be drowning in so many words that it's kind of hard, I think, to know what to grasp and what to recognize as important and what is explanatory. I just found the jury instructions as a whole surprisingly unhelpful, because it makes it so difficult to distill down to the fundamental points that the jury needs to be considering, which is really what the instructions are supposed to do.
Yeah, and I think in particularly this case, I found the substantive instructions on the charges in particular to be very convoluted, and I don't know how they're understanding them. And maybe that's part of the problem, why 4 days later they're still deliberating on charges that seem pretty straightforward. I mean, they do take a while to read. Even in New York, it takes 45 minutes to an hour with all the non-substantive charges. And every time you hear them, I mean, as a lawyer, you laugh and say, they don't understand. You may consider, a prior inconsistent statement as it relates to only the witness's credibility, but for no other purpose. I guarantee you, unless there are lawyers on that jury, none of them know what the hell that means. And they're just saying, well, all right, okay. A lot of these instructions probably don't mean much. And especially when you get bored and you've been hearing all of this stuff. But yeah, I all of this just seems, I don't know how they're grasping it.
Jury instructions written by Yellow Cottage Chales.
Yeah. Well,
and as one person said before, yes, Lally did the trick you see sometimes when they don't have any case. They put up, see, all the evidence I put up here. This is the only important one, but he put in so much, so the jury sits in the room and thinks, it's really thin, but there's all of this next to it. It must be something. And that's
it's the trial version of a discovery dump, just you don't have anything good, so just put everything out there so they won't notice what's missing.
This trial should have literally been a week long. There's no reason that it lasted this long. There's all these witnesses coming up with all the different information that all it was to do, all it was to confuse the jury, right? It's a brilliant strategy. And if it's played out thus far, I would do this in every trial in Boston if I was an attorney. If I was a prosecutor in
everybody would be trying to get out of jury duty, then everybody would be trying to get out of jury.
I just put 150 people on every witness list.
It was bizarre. I mean, when he put on all those people from inside the house, I mean, on the one hand, you could say, all right, I'm going to do that to try to push back from this theory. But as a matter of strategy, if that's the defense argument, you could say you call them, and now you're going to have to direct them instead of cross them, which is much harder. Andrea will agree with that, I'm sure, too. It's 1,000 times harder to do that and whatnot.
Especially with a not friendly witness.
Right.
They had to have those witnesses on cross because they're not friendly.
Right. And, he spent, as you know, the first 6 weeks proving that the people inside the house didn't commit this crime. And then they just kind of got to the point sort of at the end, if you can even call it that. And the defense went very fast. They just called experts really and a plow driver. And they're sitting here 4 days later trying to figure out what happened. And I got to tell you, it's stunning to me that this is happening, because it makes absolutely no sense without the conspiracy.
And Jane has it right with this one. The Alberts probably didn't buy off a jury to get a hung jury. They want a guilty verdict. So if they bought a jury and all he can get them is a hung jury, that's money wasted. And does she have to give the dynamite charge if they come back hung again?
Yes.
No.
I think they
yes
do.
And
right?
no.
Isn't it?
She could declare a mistrial. She could just accept that they're deadlocked and not send them back again. That is an option that she would have.
Really?
She doesn't have to send it back. She could say you had the weekend to think about it. You're clearly still not able to make progress, so we're going to call it done at this point. But if she is going to send them back again, she's going to have to make this finding again about whether there have been due and thorough deliberations. That's what she did the first time. Very careful use of that language. She says, "I'm finding there have not been due and thorough deliberations," because under the language of the rules, that's the finding that would trigger her having to give that dynamite charge if she's going to send them back again. And then because Massachusetts has this kind of strange to my perspective, but okay, statute that says you only get to do that one time.
Once,
you can't send them back a second time after you've done that. That's that triggering event. So it comes down to that due and thorough deliberations finding, which is discretionary with her, but it does start to get a little bit more difficult the more time has gone on. The fact that they, put a whole afternoon into it on Friday after indicating they weren't able to reach a verdict. And if they come back Monday and, say they still can't, it's getting to be a little bit, I think, more difficult to make a finding that they basically haven't done enough yet.
Right. I would be stunned, though, if they come back again and say, we're still struggling. And let's assume she makes the finding, which I think at that point would be appropriate. I mean, I think she probably could have made it based on we exhausted everything. But there's no way she's calling a mistrial without giving them the pep speech to try one more time. There's just no way. I mean, that would be.
Well, this Mark, this is why I raised that issue
that
earlier.
It's leaning
Of,
acquittal.
most of the time,
you're
it
going
would push
conspiracy?
yes. If Bev
doing it?
really
Okay.
doesn't want her acquitted, then maybe she just takes the hang.
I don't know. I mean, here's the other thing. Whatever you think of the judge, she's not stupid. Okay, she may be many things, but she's not. No, she's not like an imbecile. Stupid. I mean,
no.
What I mean is,
Not at all.
She was a legal aid
She's
lawyer.
quite crafty.
Yeah.
But my point is this: whatever. I mean, she hates Alan Jackson, she hates Yannetti, and probably hates Karen Reed. So let's get past all that. But when I say she's not an imbecile, what I mean is, two engineers with degrees that are longer than both of my arms just came in and emphatically stated, as a matter of scientific law, this didn't happen this way. She knows that means she's not guilty. And as much as she hates her, or just because, whether it's cattiness or she hates Jackson because I'm intimidated by your persona and you're an out-of-towner and you're making me look silly.
You're
on
not
TV.
making me look good. That's what
Right.
it is.
Do I really think that if she knows, and she does know, just like all of us know, she can't
She
be
saw
guilty.
Proctor too. I think that's
Right.
huge.
Take
yeah.
that too. That she's literally going to say, how am I going to make sure I get a conviction or something that doesn't let her?
Yeah.
I don't see that. Even though I don't like many things she's done, I think she'd rather have a verdict say, hey, it's on them, and get out of there and not have. I mean, does she want to do this again? Because she knows there isn't going to be a conviction.
I don't think they do this again either. I think they do this trial, and
so
no
either.
matter how it works out, that
I
we
don't know.
gave it our best shot. We couldn't get the conviction.
Yeah. That's
Here's
it.
how this would
I
happen.
don't see how they
Maliciousness
can do
from
it
this
again.
prosecution does not give me much hope that they would suddenly see the light.
It won't
Really,
be
it
suddenly.
doesn't, but
It
I
won't
think
be
that
suddenly.
it's yeah.
They will say right away, absolutely, we're going to do this. And then they take their couple of weeks and month or so that they get. And then,
No comment.
Quietly
they start
dismiss.
thinking
comment.
about it. Politically, Morrissey says, how do I do this again? How do I use Proctor again? What about Buchanan, who probably says, you know what, all things being equal, I don't want to be cross-examined, with the benefit of them having time to think about and look and actually order a transcript and see what I said about the video. The feds are still there. Do they dump more materials? They probably do. I would think eventually, are
Plus
some of
all
these
the
charges,
internet sleuths.
the internet sleuths are, like Mike said, are some of these charges acquitted already, or is that coming?
Or the
Probably.
AG too. I mean, I
You
think
have to
the
think the
governor and
murder is
AG.
going to get, even if there's a hung jury on some level, I can't fathom that they couldn't reach a verdict on the murder, because the intent evidence is ridiculous too.
Yeah.
I think that ultimately they don't try her again, even though that's not going to give the impression they're going to give right away.
Exactly. I
Brandi,
can totally see that.
we had a personal question for you. Do you know how Jen McCabe got Carrie Roberts' phone number in the end?
I don't, because I know that I would have to go back and look at all of my stuff. I have my obsessive crazy person timeline that I've looked at, because I've gone through trying to figure out how, like, what happened when Carrie Roberts got his phone too, because that was never answered. So, and I've narrowed it down, but before I say what I think, I'm going to keep on working on that. But there's been a few things that I've never been able to piece together, and that's one of them, because I know that she said that she was trying to get the number from Karen, and because she didn't have it, and that Karen didn't give it to her, but I'm not sure how she got it.
And Mark, who holds the DA's office and police accountable? What are the options for the higher officers after the verdict? Investigation and the choice to prosecute is clearly flawed.
Department of Justice, in this case, the U.S. Attorney for the District of Massachusetts, as they apparently are already looking into. But, you know, the feds are traditionally the corruption investigators, and which is also very telling. Given their interest in this months ago or a year ago, whatever it is, they don't come in because they're interested in a state murder case. They come in because they think that the police and or prosecutors involved in said murder case are engaged in some form of corruption, civil rights violations, that sort of thing. Not only that, they don't usually come in when a case is pending, which would lead me to believe that they already were looking into some of these people, whether it relates to that other case that everybody, Birchmore, that people talk about, or other reasons. They don't just literally do this. It's not unprecedented, but it's not common. So something's going on between the Norfolk DA, the state police, the Canton police, and the U.S. attorney.
And did the defense put too much faith in science? No, I thought they made it very clear that because the defense didn't need to make a week testimony, a week's worth of testimony with all kinds of people. I like what they did. They just hammered home the dog, and the car didn't hit anyone, and anyone wasn't hit by a car. So I believe it was smart of them not to burden the jury. And again, we are 6 people who 2 of you work with cases. The rest of us is amateurs who watch them. All of us are sitting here thinking, what is going on in that room with clear scientific evidence? This is reasonable doubt.
If you don't have the burden of proof and you have the science on your side, that is the best straight flush you could ever get. I mean, literally, I don't have the burden of proof and all the science supports me, which is why we sit here and scratch our heads and say, how the hell was this not acquitted 4 days ago?
Yeah. But I think when you look at people's reactions to it, like even just on social media, and I know that social media is not jury, but a lot of times it is indicative of what, you know, the way that we've seen people behave on social media and talk about cases is a lot of times the way that we have seen the jury outcomes. And when you see some of these people who are completely incapable of the understanding that you are not having to choose, you either believe this side or you believe this side, that you only have to believe that the Commonwealth's, you know, side is the only reasonable side. You don't have to believe what the defense says in order for an acquittal. And I think so many people have taken the fact that now we have this other, you know, theory that's presented to us and looking at it as they didn't prove that, and not understanding that they don't have to, the defense doesn't have to. And I wonder if some of the, even though it's not supposed to happen that way, I wonder if based on how people are reacting to it with social media stuff, I wonder if there's some of that going on in the jury too, that are thinking,
so
you know.
The jury could be subscribing to like the Coffin-Dapper theory, in other words, who just puts these things out there as a so-called, you know, trained professional and just says, oh, they didn't test the evidence. So how could their conclusions be valid? And you just, you know, smack yourself in the head and say, I can't believe that this woman was a special agent for the FBI and can't understand what they said on cross and the logic involved in that. And you're right, though. I wonder if that's how jurors are. And of course, the cynic in me says, you wonder if they're reading any of this stuff.
Of course they are. You can't.
I look at like the Law and Crime poll and the Court TV poll. To me, those are very compelling because those aren't that's the furthest from a bubble as I think we're going to find among people who are watching
Right.
the trial and just forming a bare impression of it. And even those polls are coming back, 80% to
Yeah.
90% not
Right.
guilty. That's not enough of 12 people. That means
Yeah.
there is, if it's representative, probably one or two people who are the guilty voters, just like we're seeing in those polls. I want to try to give grace to other people's perspectives, just because I don't agree with them. I don't want to just dismiss everybody who would have a counter point of view as being thoroughly unreasonable or something like that.
Unless
And I
they're a
think that's
kook, unless
especially-
there's a kook on the jury.
Well,
I love that.
Sorry,
there can be
that's-
kooks.
The one kook.
One
But
kook
so
is all it
I
takes.
think it's important to steelman. It's important to steelman the opposing position. That is what lawyers do. That's what a good lawyer needs to do, because you have to anticipate how somebody who is reflexively against you is potentially going to be looking at the case. And that's where I keep circling back to the tail light and just the difficulty of being able to establish, a frame up, giving that very narrow window. And I think exactly what Brandi here is pointing out, the jurors are lay people. They are not lawyers who appreciate or even agree with these fine distinctions that we lawyers like about who has the burden of proof. How do we make sure we are not shifting that burden of proof inadvertently to the other side? Do we appreciate the reason why we have these principles in this first place is this idea that it's better for 100 guilty men to go free than one innocent man to be imprisoned. A lot of people don't agree with that. They're perfectly fine to put the innocent people away as long as they make sure they guilt that guilty person. There's some people who will just be constitutionally offended at the idea of somebody who did something wrong getting away scot-free for it. So I try to appreciate that there are potentially perspectives like this on the jury and get a sense of how they might be looking at this case. And I keep coming back to the tail light, the idea that it was a very, I think, high risk, high reward strategy that the defense took with going all in on the Karen Reed is framed approach, because it does run that risk of setting it up as a binary choice to jurors who are not necessarily thinking in a sophisticated way about how do we work through all of these legal nuances. They, I think, are coming at it from a human perspective. They just want to know what happened, and they want to try to figure out what happened. And so,
but in this case, it's so hard because, as Lusamon says here, did anyone back up Carrie's testimony about the prayer group? No. And again, there's so many. If you have to love Brandi, because she makes all of these timelines, so all of us can just leech off of her.
True.
Because if she made everyone's timeline on top of each other, nothing matches anything. And Lally changed his timeline 3 times during those 28 days of trial. He changed his timeline 3 times. And can they find her guilty? Not guilty on manslaughter, but guilty on the lesser charges? Yes.
Yes.
And that's most likely what is going to happen. It's going to be a compromise verdict if there's a big minority on either side. They will try and say, but let's just give her the lesser one, because it won't be that long.
I
And you never know. No.
It's the
I'd have
car
the same-
accident again. Because now you're saying there's a car accident, but we're fighting over intent or negligence or recklessness. But how are you going to get 12 people to even compromise and agree in theory on the threshold issue of whether the car accident happened?
there was a car accident.
That's why, I mean, it ought to be an all or nothing, although obviously if you get convicted of the top charge, you never get to some of the other ones. But that's why I think from the DA's perspective, hung jury is as good as it's ever going to get. Another reason why I don't think they're going to retry the case. They're at their high watermark right now.
Yeah.
I mean, they've got to be sitting there
Best they can
the
get.
DA's office saying, how in the hell is this happening right now? This is a good thing for us. It's never going to get better. You give Jackson and Yannetti a chance to recalibrate, look at a transcript, think about different strategies to add this, maybe subtract that. Maybe, for example, They didn't go in enough with the Dighton cop, which might have answered a lot of the question about the taillight. I mean, they got it out there, but they didn't do much with it. You know, that's kind of a powerful
Agreed.
thing.
Get the tow
Agreed.
driver on next time.
The praying in the back of the car about the Google search, they could have isolated the exact time based on the video in the car when when the Google search was made by the DA's theory.
Where were they? Where were
the car right there? Is she in the car? Is she with Karen? Are they praying? What are they doing? If not, it's not likely. You give these guys another chance, they're not going to lose.
And when you look at the timeline for things like that, because I thought the exact same thing that you're saying. If they're saying that they're in the car, then there will be the dash cam video will pick up the audio for that. But it didn't. And then when Jen McCabe said that she made the search and she was shaking her hand and her hands were cold and that's why it was typo, whatever. And she said that she made the search and then she didn't look at the results or didn't get to the results because then they were moving John, so she had to move. I pulled that up on the timeline. I went back and I pulled the dash cam at 6:24 or whatever it was. It was she said at 6:23 and 6:24 is when she supposedly made that Google search. John had been in the ambulance for 10 minutes. So for her to say that, this is how it happened and then we stopped because they were moving John. John had been in the ambulance for 10 minutes. They were not moving John.
Right.
So the timelines don't add up and they don't make sense.
And suppose they retry the case and the defense now is going to get transcript for 60-something witnesses, right? They're going to have another round of inconsistent statements and nonsense. And what is the DA getting? Dr. Russell, who says these are dog bites, who's going to say the exact same thing. The other medical examiner who's going to say the exact same thing. The ARCA guys who are going to say the exact same thing. And maybe the lucky transcript makes a little mess for them. Maybe not. But it'll be such a huge advantage for them the second time around.
Jen McCabe also testified that her text messages at the end of her and John O'Keefe's text messages, when she was talking about hello, where are you? The pull behind me. Most of those, the last, I think 3 of those text messages on the stand, she says that she went to the window and looked out and there was some event outside that led to those text messages. But the problem with that is Karen Reed was back at the house at 12:36.
Right.
Yeah.
So 3 of those text messages at the very least happened after Karen Reed was already at John O'Keefe's house.
The other thing I thought they might have left on the and it's all, again, this is how they're going to think if they have to do this again, which I still don't think they will. But one of the things I think they left on the table, especially when you're going after McCabe and the Google search and all the other stuff, was this really bizarre testimony that the night or the next day after this happened, that she went to Juliana Nagel, who just happens to be the witness who sees nothing and then sees the blob. And then by the end of it, it turns into a 6'2" man who might as well have been wearing a shirt that said, "My name is John O'Keefe," according to what she claimed. That McCabe went up to her for no real reason and said, "I need to inspect your text messages."
Yeah.
I mean, that to me takes on a lot more importance than maybe it was given, because that is weird. And when you put it with all the other butt dials, Google searches, staring out the window, seeing Karen Reed when she's already, like you said, picking up the Wi-Fi across town. I don't know how.
As Furious says here, if she really yelled it, I did it at the scene. Why didn't they entertain her?
Yeah.
Why? It's so stupid. And then you have Cirilia from Sweden, Exhibit 102 from the 823 wellness check at One Meadow shows a pretty busted tail light. Well before Proctor got to the car, Lally showed it about 3/4 into his closing. Could have assuaged the jury. It could have, but we watched that picture a lot of times on mine, and what I got was there was too much of a straight line to be a busted tail light, and you could see the snow had been coming from the right. So again, you will look at it, and if that's what I had a problem with Bukaknik and the drinks, as Andrea mentioned earlier. We were told in the beginning, don't narrate the videos, and he narrated that entire video, and that was a very big problem for me, because
you're not supposed to do that. I mean, that's
the video speaks for itself. It's the
there
best
have
evidence.
Been many reversals in New York. 90% of them all apparently are in the Bronx. The DA's office up there apparently does this all the time. But they have witnesses tell the jury what the video shows, which is not proper. The jury is the fact finder. They don't, the cop doesn't get to give his opinion on what a video shows. But, something else you mentioned, which I think is really interesting, the I hit him, which apparently is a big deal for the DA. I mean, they led with it in their summation, and this could be part of the problem with the juror. When you said, why not take her in custody? I don't even think you have to go that far, but in the next trial, I would expect there would be a ton of cross-examination about, never mind taking her in custody. Where are the cops to say, ma'am, what are you talking about? Did you punch him? Did you run him over? I mean, because I hit him. Why would that imply car accident? That implies like decking him or hitting him in the head with a bat or something. And nobody there who claims she heard her say that took any step to say, what is this crazy lady talking about? And might she have killed him, whether it's on purpose or not?
Firefighter No Friends did say that a cop asked, what are you saying? And then the cop said, nah, I never heard that. But Lynn is asking, our position is the jury should be read the Chuy Rodriguez instruction and go from there. The Chuy Rodriguez is the Allen motion that they should go back and try and reconcile the differences and see if their positions are as strong as they believe they are.
We talked about it earlier, and we referred to it as the dynamite charge, I believe. That's what we were talking about, is the Chuy Rodriguez thing.
These are very interesting instructions because they have to walk an extremely fine line between making sure the jury understands that a verdict is desirable, but also making sure that the jury understands they have an obligation to decide the case in accordance with their own conscience. And that means that some cases will not be decided. They will not be able to reach a verdict. A jury is not legally obligated to reach a verdict. There's a great case, Mark, from back in New York in like the 1800s or something like that. I've seen this language quoted in many places. It talks about at common law, the whole point was to coerce a jury verdict. They would lock the jury up without beds, without food, without drink. If a judge needed to go to the next town, he would throw them in the back of the cart until they reached their verdict. And so that's the way things used to be done. But we have a very different perspective on that now, that coercing the jury into the verdict is not lawful. So these instructions are really there to walk a very fine line between, jury, please give it your best shot and understand that we'd really like you to be able to solve this. But they cannot push them. They cannot put pressure on the minority to abandon their position. They cannot suggest that they have some kind of duty to render a verdict. So that's what the instruction is intended to accomplish.
But it gets interesting because, like we discussed earlier, Andrea, this is kind of like the backwards case. I mean, normally, if the defense is concerned that, say, it's 11-1, and I've got one true soldier hanging on, and then the judge says, "I'm going to give them the whatever they call it in Massachusetts,
Chuy Rodriguez
dynamite charge." That's when you would see a defense attorney jump out of their seat and say, "You can't do that. I need to make a record. You should be dismissing them now." And then, because if they tilt that last juror, and it becomes a conviction, and the charge, as Andrea said, is too intense, then there's an argument on appeal that, the verdict was essentially coerced and the judge screwed up by not dismissing the jury. But in this situation, I think she would be, if anything, trying to stop an acquittal. So it's, there'd be no one to appeal. It's interesting.
Well, let me ask real quick, if sequestering the jury at this point, it would be in the cards at all, because the reason that I ask is after the craziness the other day on Friday, right? Because there's something like 3,000 people in there or out in the lawn.
Too late.
Yeah.
This is something she would have had to notify them before, because it could also impact their ability to serve if they have plans on the weekend, and you're going to be a juror for 2 months.
Childcare.
Yeah, and you're going to be living in a hotel and some godforsaken days in, and like Needham or wherever, I don't know, whatever they would do. I mean, you'd have to give them much more notice. I mean, at a minimum, you'd have to discuss it with them right before deliberations, but you couldn't do it now.
And I have to think the cat is out of the bag as far as the jury being aware of what's going on.
They hear
outside.
it.
They already know.
Everyone knows what's going on after 2 months, because I know they all answer, no, we didn't look, but all of them might have seen something. And
Well,
Mark and
it's-
Andrea, do you think the possible of an bias
Intrinsic.
against defense? Big $5 words, I don't do those. Against defense attorneys and defense cases in chief might be holding one or two jury backs despite the irrefutable evidence.
But that's kind of like bigger than this case, right? That would be a concern that you would have in any case. And the reality is, these three lawyers are professional. They're very good. They're polite with the jury. I mean, they don't come off as dirtbags and, sleazy lawyers. I mean, Karen Reed is, as you can imagine, your most non-traditional defendant that could ever be. I mean, you just don't see generally female successful women being tried for murdering their boyfriend. It happens, but it's not common. And I don't know. I find it hard to believe that the problem here is this just, intrinsic dislike for defendants and defense attorneys. And because that could be on any case, it has nothing to do with any of the personalities and evidence here.
Yeah, that's
And,
just one of the things that's so predictable in a potential juror that it's going to be part of your selection process is really going to be trying to feel that out. So when I would do voir dire and I'm questioning jurors, I don't care, like Marcus said before, I don't care about things like your demographics, your job, stuff like it tells me, I don't care who you vote for. It tells me very little about you. There are some fundamental things about how you think. That's what I want to know. And the main thing I want to know is, are you open? Are you somebody who is willing to consider things from a different perspective, or are you somebody who makes up your mind quickly and then that's it, and then you're stuck? I, as a defense attorney, typically want people who are going to be open because they're going to sit through the prosecution's entire case before they ever hear from me. And so if they have closed their minds at that point, then it doesn't matter really how good my case is. If that's just their personality and their way of processing, that's not going to be a good juror for my case. So these guys are extremely experienced. I'm sure they have, picked more juries than, definitely more than I have. So you do just have to assume that they have their own ways of trying to root that kind of thing out. Again, the problem with juries is that sometimes you are just making the best of bad choices. You don't get to choose the panel. You don't get to choose the options that are there in front of you. So you can be stuck. These two are both really bad, but I'm going to be stuck with one of them. So pick my poison. You can never rule that out.
Yeah. And then there's the doomsday scenario that you can never rule out, which is the sleeper agent kook. The person who just decides, I'm going to lay low, be even keeled, answer all the questions correctly, but I'm just going to get on there and, wreak havoc. I mean, look, it's weird. It can happen. I don't know that that's the case here, but there are a lot of weird people who are attracted for their own reasons to be on a jury that has nothing to do with, I'm going to do the right thing and be open-minded and mete out justice just for their own reasons.
Especially with this too, because it's going to be headlines. They could be lying about it, and they could be like, "I'm going to be the star." That's what I'm worried about. It's like, there's been so many people who have wanted to be the star for like
put
no
it this
good
way.
reason in this.
Suppose there is a hung jury, and the first thing the media is going to try to figure out is what's the count. I mean, obviously, they're not going to tell the judge that, but all the reporters are going to say, "Let's find out." They're going to try to find the jurors. Of all those 12 jurors, who's going to be the media star? The one. That's, and you hope that
he's going to be on The View the next day.
They will be on national TV in every newspaper as
Murdoch.
Yeah.
Take the Murdoch case where they had the suitcase packed when the verdict came in so they could fly to New York. And Stormy says, if a juror knew who hired Arca, we would have a not guilty. They need to ask Arca who was hired by it. No, they can't do that.
It won't be allowed,
They have to know. I mean, that's the other thing, which is how do they not know? You've heard.
I wondered about that. I wonder if they because they did make it a point to say that we were not
agency
the ones that hired you.
Used the word agency, which means government.
They did use agency,
and you heard the word FBI slip out at least once or twice. About all this other testimony in other proceedings, which, again, once the FBI slips out, And then one of the most effective things Jackson did in building up to the opinion was spending a good 10 minutes on, another agency, and both sides had access to you, and da 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 da. I mean, to me, they have to know. And there's put it this way, police officer on the jury, he's not telling them, guys.
Yeah,
that's the FBI.
And the rumor has 2 lawyers on there too. They should say it. And how much do you think Karen's actions and behavior that evening are factoring, driving while presumably drunk, and her aggressive message? Well, it factors in as much as the jury believes it factors in. Again, I was watching the Caroline Tyler case out of Massachusetts as well. She was very friendly with her girlfriend. Said, "Yeah, I'm coming home soon, and see you later." That was held against her because that's the funny thing. When a prosecutor reads your text, here's your email, here's your voicemail, everything is shady because you must. And it's up for them to present it in a way so the jury believes that it is shady. And that's one of
the best things Jackson did in this. I mean, did obviously a lot of really good things in the summation because he's really good. But I thought one of the best points specifically he made was dealing with the text messages and how the tone changed based upon what she had to be perceiving from "I'm pissed off, he's not coming out," and how the tone is changing more to concern because I'm not hearing from him. And to me, all of that in terms of value to motive or anything is just a giant nothing burger. I mean,
the number of times, because the fact that they pointed out that she called 53 times.
Yeah, that's not helpful.
That's not 53 times is not, and like Lally's wanting to say, like, see, she's a crazy woman. Okay, yeah, like, no crap. Like she thinks he's out partying or at another woman's house or whatever she thinks at this point. Like, she's calling him because she obviously doesn't know. Like, to me, that goes completely against what the couple is saying, because you're not going to call, like, the Caroline Tyler trial. She called maybe twice and left 2 different voicemails or something. You don't call him 53 times.
Lally's cover-up theory of her leaving 53 messages to show, leaving my shoes on. Oh, that's the mistake, apparently, right? Yeah. That's the one that slipped. And then deliberately backing into his car at, 4 miles an hour. You'd think she might have given it a little more.
Give it a whack.
I mean, he's just grasping at straws. And yet, here we are.
He is, but I do think there is something, there is a kernel there in that question that's definitely a risk that the jury prejudges your client, or one or more of the jurors who has a judgmental, not agreeable, doesn't tend to like people kind of mindset. They walk in and they see somebody sitting at a defendant's table and they think that person sucks. I wonder what they did. And you do your best to try to weed that out through jury selection, but you can't always get just the people that you would like to have on there. And so this then brings us back to the sort of age-old question, the real sort of heart of the strategic decision in this case, which is, should Karen have testified? I personally, this is an area where lawyers have opinions all over the spectrum. I recognize mine is the minority opinion, but everything else being equal, if it is not going to tank my case, I am putting my client on the stand. And it's because I recognize the jury has spent 2 months here. They've been watching her. They've been thinking about her. They've been looking at these texts. They've been hearing all of these things about her. They've been encouraged to judge her one way or another. And they simply want to get a feel for her and who she is and understand her perspective. It's very, very natural for them to be curious about that. I think the other piece of it in this particular case too, that's always a little bit of a challenge. Yes, the jury is instructed, you can't hold her decision not to testify against her. She doesn't have any burden to do that. But it's kind of normal for people to look at a case where they are alleging certain events took place to want to hear it from her. It's normal for them, I think, to look at this and think, well, if we're evaluating whether John could have hit him, could have thrown the tail light thrown the glass into the tail light and busted it that way, she would know. If we want to know when did she leave and get back to to One Meadows Ave so that we can get the timing on these text messages, she would know. And so it's very hard to sell a jury on an alternative theory of a case when you have a defendant who would be expected to substantiate that and support that, but who doesn't testify. It's that distinction between, if I'm arguing a pure reasonable doubt case, I'm just pointing out there's a lot of things that are possible here. But when I'm pointing to an alternative theory, I'm saying something else happened. And yes, the defense has no burden of proof, and that's technically there in the jury instructions, but the jurors are not trained legal professionals. They're trying to come at this as people with common sense. And I really do think it's just normal for them to wonder, why wouldn't she just tell us what happened?
This one, I'm going to disagree with you 180.
I said I'm the minority.
No, you've argued a very compelling position, but
It's a valid point.
obviously there's always the concern about what happens if the client doesn't testify. They're going to speculate. There's no way around that. But the way I look at it is you can't yield to the pressure and the cheese unless, I just had a client testify last week for probably the second or third time in my life. And the reason she had to testify was there was critical evidence that had to be in front of the jury, and there was no other way. This went to her knowledge of something, and getting abused was critical to come out, and there was no other way to get it out. But the problem, I think, with Karen Reed testifying is a number of things. Number one, she's not giving you anything, because she's going to say, I hit him, and I don't know, maybe I did, maybe I didn't. That's not adding anything other than risk. Also, she gave some interviews that, are not great. Let's be honest. They're
The
not
Nightline one, right?
They're not great. They're not the worst thing I've heard in the world, but they're not great. And they do, in theory, suggest that, maybe there's some veering of story here, which I don't believe, but I think the risk is that some jurors believe. And if she's given what their defense was, something happened in the house, what does Karen Reed offer to that? Nothing. If Proctor planted evidence, what does Karen Reed offer to that? Nothing. If, she could say, I suppose, that I wasn't sitting with, McCabe when she claims that she Googled, Hoslong to die in the cold at 6:30 in the morning. So maybe that was something. But to me, this one's a no-brainer to me. I wouldn't have obviously it's her choice. I shouldn't say I wouldn't but she's going to follow her lawyer's advice because she has real lawyers.
Yes, she is.
There's no question. And look, another red flag why I don't think she should testify. She makes a lot of comments after court, right? Like to the press, none of which are stupid, by the way. They're all actually quite intelligent and saying, I want to testify and this and that. But as a lawyer, you're like, why are you doing this? Like, I really wish you would just not talk. And if you saw the very end of the trial, they were shepherding her away, like not maybe as much as they were in the beginning out of concern about that. But to me, this one was never a doubt, no chance that she would ever testify because she has nothing to add with too much risk.
The only thing
that is common knowledge.
The only thing that sticks out now is obviously we're in this weird hung jury position. So it might have benefited her, but up until, Friday, I would have totally.
But it could hurt her too. It could.
How many young girls did you claim John slept with? Did you really yell when you drove past his baby, that girl's house? Where were you when the
Aruba
incident picked up? And she would be saying, I don't know anything.
I hear all of this. I really do. I just want to reiterate that I think I agree completely with Mark. I'm not sure that substantively there's a ton for her to add. I'm really looking at this from much more of a psychological perspective, and just from what my experience, jurors want. They want to hear from the accused, and they, in my experience, will be remarkably forgiving with personal shortcomings in the accused, because part of what they're doing here, they're getting these competing messages about who this person is. And there's the risk they're projecting all of this stuff that they're imagining on the defendant. It is much harder to do that with somebody who is a real human now, somebody that has gotten on the stand and spoken and interacted, and you've been able to witness that. The example that I will just leave on is that the trial that I had where I put a convicted sex offender on the stand to testify in a failure to register case, because I had talked to him and he was a very likable person. He had a good explanation for why he hadn't been registering. There's pretty much nobody less sympathetic on the scorecards than a convicted sex offender who is homeless and not registering. But we got the acquittal because the jury understands people on a human level. They want to be able to have that information. I recognize this is not science. This is not, again, the common wisdom. It's really just my preference and how I've developed my practice. I would have put her on the stand if there was any way for me to do that and not blow up the case. I haven't seen all of the interviews, so I don't know if there's something in there that's just so bad it can't be dealt with. I don't know what the truth of the situation is. I don't know if she can testify truthfully to something that doesn't, inculpate her in at least some kind of crime, even if it's only maybe drunk driving. So I don't have that information to be able to make that decision like Mr. Jackson and Mr. Yannetti do. But if those things aren't on the table, I can prep her. I can prep her on problems with the interview. I can prep her on problems with the way that the Commonwealth has sort of presented her and pitched her through these texts and things like that. We can work through that. And to me, that's an important part of my role as the defense attorney, is to remind her, you're okay. You're a good person. You're a decent person. You're entitled to be heard. You are taking your power back by allowing your voice to influence this process. I realize that is the minority position.
Yeah.
The other concern is,
I have had case pulled up for a long time. The jury question had QQQ on it. I wonder if they watch YouTube, or is that common on the question that gets sent from? I don't understand what QQQ.
I think she's saying, are they watching when they're not supposed to? I mean, they say they're not, so there's nothing you can do. Let me just add one final thought about it when a defendant testifies, particularly someone like Karen Reed, who is a successful woman accused of killing her boyfriend. Everyone wants to know, like, is she going to testify? And obviously, in every single case, the jury wants to hear it. They're told they can't consider it every case. That's a concern. But when you have a really good defense like they have with a ton of reasonable doubt, you're trying to minimize exposure and not do anything that could increase it. And when she testifies, the risk is this becomes a referendum on her credibility. And if she comes off as less than credible, well, then she's probably a killer. As stupid as that sounds, and that's not the standard they should use, you're making her credibility much more important than proctors and all these other people. And that's what they're going to obsess over. And sometimes if you need it, if it's like a tough case, I can understand it. But from their perspective, there's so much reasonable doubt. Why run the risk of doing anything that could upset, the equilibrium here?
And a lot of people have been saying her facial, she has a resting B face. And again, and we know from the Murdoch trial, he lost that trial when he took the stand because he was
he did. He was a train wreck. He lost the case for himself. I can't put that client on the stand.
And Anton Ivanov has a way to fix this because in the papal election in 68 to 71, city of Bederow grew frustrated by the long deliberation. They locked the cardinals in the building, starved them, and tore the roof off to deprive them of a shelter. I don't know if a day's in...
The good old days.
Yes, but I saw some... I just went to Tennessee and I was looking at some hotels. I think I would have taken a church without a roof.
Without a roof? Yeah. There's a couple of those.
And we must acknowledge there are some people out there that hate math. And to appalled by is one of them.
Yeah, you just stole my thunder. He can't add it. He can't add it and subtract it.
And then you have the phenom called aphantasia, being unable to picture in the mind. That physics testimony was all math. Yeah, I would have liked the demonstrative, but I'm a very... I see things in pictures. I like to, when someone is talking about a crime scene when I'm on jury duty, I like to pay to draw it, so I know. Oh, he was on that side of a car. That doesn't add up with what he just claimed and stuff like that. So I like demonstratives, but
Yeah.
I don't know if Bev has a ruling against it. Maybe she might have.
She did talk about chalks, right? She was talking about what they call demonstratives at some point. So maybe she's got like a thing.
I don't know what happened to all that microdots stuff. That
Right.
these fantastic things that I thought the understanding was that some of that was going to come in, and it never did. And I'm assuming she said no.
Yeah, I think she excluded a lot more stuff than we're not
Yeah.
aware of, is from what I'm hearing.
Is it true that Brian Albert and Brian Higgins don't speak anymore? I can't tell you. I don't know them. I don't think I would like to know them. They seem like really nasty guys. So
We
I
heard
wouldn't talk
about
to either
that.
one of them.
Yeah, we heard about that in one of the pretrial hearings. They had talked about when they were reading out the text that when they were trying to contact Higgins, they were saying, I can't remember what the exact wording was, but it was something about, why are you not talking to us anymore? What, where have you been? Whatever, something like that. So that's, I think, probably where that came from, because it does sound like that he kind of dipped out after everything went crazy.
He ghosted him.
He ghosted him.
Well, also,
whacked
another tell is when Higgins was getting cross-examined, I mean, most of this was sustained, but, the cat's out of the bag, the toothpaste can't go back in. Oh, yeah, Higgins beat up the other cop, and even Berkowitz is scared of him about Albert. I mean, those are things that if you're protecting him in that setting, you're probably not saying if you really care about him at that point.
Exactly.
Oh, and so someone is talking about the amount of times he called, and that wasn't some girl just convicted of stalking because she called a guy. How much was it? It was 20 times a minute or something for
how do you do
a long period of time. She just kept calling him, so she got a stalking charge.
Gentlemen, if you find yourself in this situation, run away, run far, far away, change your name. Don't give your address. Don't start social media. Just run away.
Does that happen to you?
No comment, sir. No comment.
Oh, wow.
Valhalla have been bouncing on the most prestigious college fund for ladies establishment all over the East Coast. So he might have met one or two special ladies.
It was a lot of fun, though.
Oh, baby reindeer. Yeah, that one was one of the.
Oh, yeah.
Oh goodness, y'all.
But also though, speaking, well, never mind. No, I can say it. Whatever. I'm allowed to have opinions.
Get it, girl.
Trolls. Is it not okay? So Proctor and his sister talk 5 or 6 times a day.
Yes.
That's weird.
Is that
What's over that?
That's weird.
Does
That
anybody
is
talk
weird.
to their look? I love my brother. My
No.
brother and I are very close, but
No.
I talk to my brother like we'll text back and forth, sometimes. But
I don't even think I talk to my wife that much.
If I remember to call my brother on his birthday, it's a good year.
Right?
A text. I sent him a text.
Really
on his
weird, unless they had offered an explanation that they went through a family tragedy or something that made them in particular. But his testimony was just, we talk 5 or 6 times a day, and how's it going? So, that murder case is going well, and, we're going to arrest her today, and we're getting gifts for you or my wife. I mean, typical normal brother-sister stuff, right?
Yeah.
I can
Brandy,
tell
while we're
you.
throwing out the small details that I just find very hard to believe, does anybody really believe that Brian Albert has no whiskey in his house?
no.
Did anybody buy that?
Not even
I
a
don't
little
buy
bit.
that.
Or that Higgins is
They've
leaving,
got a whole
No,
bar.
he left right
or
away.
that Higgins is leaving as a result to go
Right.
to
I
go
wonder why he
move cars
left.
drunk.
I wonder
They
why
don't
he
have
really
Jameson.
left.
This is
Fintech.
like his best friend. He's going to have a bottle of his favorite drink there at his house.
Yeah,
I
if you
mean,
don't have
I
any
don't
whiskey,
buy that for a second.
I'm going to the police station to move cars drunk if you don't give me
Yeah.
whiskey.
Right. Makes
This
total
sounds
sense.
much better.
I can tell you honestly that most of my friends around here have Yingling in their fridge, and it's not for them, right?
Yeah.
It's for me. It's there when I show up. It's ready. It's available.
Go
Yeah.
Phils.
I have like 3 or 4 different. I have like a little mini bar, and I have like 3 or 4 different kinds of liquor that have. Some of them have been here for
Years. Yeah. I have the same
yeah,
thing.
like for the longest time,
I got a
because
closet.
people will bring stuff. Yeah, like people like, or like I'll have stuff for certain friends when they come to visit, and because where I live, people come down and vacation a lot. So when I have people over, I'll get what they want, and then it'll stay here until they come back next year and on vacation. And but
and again,
Exactly
this
the
is
reason I have one White Claw in my fridge that's been there for like 5 years for the party where
Kyle
somebody
is
left it.
sponsored by White Claw.
There's 2 Truly that I don't know where they came from, but they've been in the fridge for like months, and they'll stay there till whoever brought them
but
comes
again,
back.
it's such a weak. I don't know about you, but if I'd been at a bar, had 6 whiskeys, been drinking all day, and all of a sudden I remember, oh, by the way, I can't drunk drive in my company car. I have to do it in my private car. Then it's fine. Then I go to a house after I had been standing doing the Rhino shuffle with Brian Alberts in the bar, and then pointing at a guy and say, "Get out here." And then I go around the house, look at pictures, and then someone says, "Do you want a beer?" "No, I'm not a beer drinker." "Do you have some scotch?" "Nope." "Well, if I'm going to be here for an hour, and then I'm going to go move a car."
right,
Yeah.
right.
It's such a stupid. Valhalla brought me a Colt 45. And I
You're
drank
damn right
that
I
even-
did.
Yeah. Well,
just
it's
to
up there
try
with
it.
I
Were they
upgraded
all
my
out of
phone
hands?
because my
What happened?
birthday was 3 weeks ago.
Right.
The explanations in this case are just I feel so gaslit by
Yes.
they
And that's
honestly
exactly
think I would
what it
believe
is.
this.
That's exactly what it is. They're gaslighting
Yeah.
everybody.
Yeah.
They're
'Cause if it
trying
were-
to
if
come
the
up
shoe
with
were on the
stupid
other foot,
excuses.
and this were all of these excuses, like think about like if the shoe were on the other foot, this is a defendant who is sitting here telling you, oh, I can explain this and 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 this, and telling you
Yes.
all of these things to just explain it away, we would all be like BS. But because they're not the ones on trial, then it's like we're not allowed to have that same level of skepticism on the constant, oh, I can explain, let me explain, this is nothing, and all of these things that don't make sense. So it's almost like that same skepticism that we would have had if it was a defendant, we're now being told we're not allowed to have because they're not the defendant. And that's not really how my mind works. Like, I'm going to be
100%,
skeptical
Brandi.
regardless.
Yes.
And
100%.
I will just tell you, if any of you come to Denmark and visit me, I have my lord.
My lord. If you don't know what it is, y'all, it's a Basque liquor out of Chicago, and it's absolutely terrible. It's the worst liquor in the world.
It's not the not
the
the
taste
taste,
like?
it's the aftertaste, and it lasts for days. But and the funny part, I had like
Really
I had a
selling it there.
Yeah, I know.
Bad. It's so bad.
It was a gift from FD Food Fairy. I liked the shirt she got me way better, but when I came home and I took my suitcase out, I thought, it's funny, it smells like my lord. And I had a 6-pack, and one guy somewhere in an airport had opened one of them, taken a swig of it, and didn't put the cap back on it. So I had my lord all over my suitcase. Your TSA dollars for... I just... well, I'm just happy he drank my lord. That's crap. He didn't eat my moon pie.
The moon pies. I love moon pies.
Baker came to America about a month and a half ago, y'all, and we basically just force fed him all of the horrible things we could find. So he had the best of experiences.
I had a great time.
Like
When I was
Colt
stupid,
45.
Like Colt 45, yes, sir.
I would say
No
green
hands?
fried- green fried tomatoes were worse than Colt 45s.
I love fried green tomatoes. You didn't have the right kind then. You didn't have them made right, because fried green tomatoes are one of God's gift to the
He
world.
called them sour.
Sour? You didn't have them made right then. Fried green
Plus
tomatoes.
Baker
Are good.
loves my lord.
Of course he does.
Yeah, I'm drinking after Germany beat us in football yesterday. That wasn't good. So, no, but it the funny part is just we're sitting here. How many days have been sitting here now?
It's been
Almost 40 days.
almost 40.
Yeah, and no one. Well, at least we get a lot of praise for a great panel, and we have a great panel. Thank you so much. But everyone is asking questions Do you think the jury needs a timeline and didn't know what notes to take in order to go back months to compare? Thank you for the best panel. I think Lally put up a timeline, and I think that was a smart move. The problem was he had changed his time in that. And how about him putting the niece's name on the screen and mentioning her 3 times during closing?
Yeah,
Why
that was
wasn't
gross.
he instructed by Bev that he wasn't allowed to do that?
Because he's just not thinking. He knew, but his timeline, though, I thought was funny because it kind of looked like the visualization of how you picture his brain when he talks. It was just like cluttered words that had no real relation. But I think as far as the first issue, it's what Andrea said earlier. How can you trust him with the note taking when Lally's talking? You could be missing a ton. I mean, I was in court one day and I almost fell asleep. I definitely tuned him out for pockets of time, and watching on the stream, everyone's done that. God knows what you've missed, and you may have missed some serious inconsistencies, mistakes that they made, and you can go back and rewatch.
Well, Lally, even on his timeline, he had the miles per hour wrong. He was saying 24.5 or 25, whatever the hell it was, and the timeline itself had a different
right.
It's like, what are you doing, man?
Yeah.
Right.
What are you doing?
And he didn't have the time of what he says, the accident was. He had the time of going in reverse, but the specific thing that, that he's arguing for, he didn't have on there. And then some of the things that kind of, went against that, of course, obviously he left those off too. But, it is different though with us, because it is hard as much as I try, and I sit there and as I'm streaming, I can't catch everything. So I download, the stuff and go through the transcripts and stuff at the end of, when I'm working on the podcast episodes, because I can't, even when I'm trying so hard, I can't focus on everything he says, because he's a dial tone. So think about, though, the things that we get to do. We can go back and we can watch it again. We can talk about, this to other people and they hear other things. We can look at what social media is saying. We can, tune into panels like this where we're all discussing it. And we get all of that. And so we pick up on a lot of things that we didn't, and things will stay clearer in our minds, but they haven't had that opportunity. So could you imagine?
Nope.
Think about having to watch the stream of Lally since the end of April and everything, and not being allowed to discuss it one time or rewatch anything. And now all of a sudden here you are, and you're sent in a room with 11 other people, like, all right, y'all go, figure out what you think. Like, so I can understand why it's, there's
Taking a while.
Yeah. They have a lot to discuss, I guess.
I fell asleep at least twice watching him, like on the couch, just like out, woke up and the stream's like over. Like,
is it the box of Cohibas that's holding the?
I think so.
Yeah. But that's
do we know if
thing
the jurors have their phones?
But I'm thinking about this too, because we all know they have been home watching internet, and imagine if one of them is watching the wonderful the young Jurks, and the other one is watching court TV.
Those are two vastly different aspects to
they
this.
Will
this
never.
thing.
They will fight harder than KDP and Turtle Boy, because I haven't seen court TV as
Jill Daniels
biased as they have been in this trial. They found her guilty half a year ago.
Yeah,
it's really disheartening and I always make fun of court TV, because I don't understand people want to watch a trial without any commentary, because there was 17,000 people watching Celine Dion the other day, and I'm thinking you could be over at our channels and have fun.
Guilty.
I love watching that.
But at least you come in and you come in and you give a rundown and talk a bit. People are just sitting and watching Celine Dion, and you're thinking,
well,
at least Valhalla tells stories, and I say stupid things. And
here's a little insight about the fan. If you've been in the courtroom, there's actually several of them. It's not just one.
So it's not an only fan. There's multiple.
No,
They're
My
all-
whole life is a
has
lie.
5 or 6 siblings. Yes.
Oh no!
My
Yes.
whole life is a
You've
lie.
all been misled.
You can see it sometimes when they feel they go up. You can see sometimes the multiple.
There are
I didn't know how many, but I knew there was
lots of
multiple. Yeah,
I
5.
just want them to move
So-
the camera that little bit so it
And
gets
center
centered.
it. Yeah, it drives me
It
nuts.
ruins my
OCD
OCD
hits so
whenever I
hard.
have
It
to
used to
sit
be.
in front of
Remember, it used to be a clock when it was in the other courtroom. It was a
Yes.
clock.
Clock's way
Yeah.
better.
Yeah,
I don't
love
get
the clock.
motion sickness from watching the
I
clock.
went from a clock to a
Deputy
fan.
heard they had that wonderful it was like it was outside in the front of the courtroom, like a not a statue, but like a carving, and the justice. It was like this very inspiring
Elaborate thing.
kind of symbol that we all got to watch.
I'm personally a fan of the state symbols, the state seals, rather.
Mhm.
When they
Yeah.
put the seals on, I like that. That's I'm okay with
Yes.
that.
I had
Yeah.
we had fun on my channel one day. I told everybody, because we were watching the state seal for so long on a verdict watch. I told people to create their own state seal and send it to me, and I'd show them, and they had to explain what it meant. And that was actually really fun. Like it was entertaining to see people creating their own state seals on what they. So it's like instead of like whatever Wisconsin is, it had like cheese and beer and stuff on their state seal, and like different ones were different, but that was fun. But yeah, the fan is a little bit
I can't watch it. It makes me sick.
And what if someone like Plevin was on the jury? What would he do?
Oh.
Probably
He would troll.
Yeah.
He would troll the
Yeah.
majority.
Get a book
He would troll the majority.
he would be tweeting everyone to try and get some clout. So
He'd
could
be
make
taking
some money.
notes every day and taking them home for his transcript for his book later.
Practicing his summation that he gave.
Gross.
I defended him too. I defended him, and then he started
Well,
trolling
I
me.
hope you learned your lesson.
Yeah,
I
never
did really
again.
bad,
Never
too.
again.
It's pretty ridiculous that we defended him.
But could the jury possibly be thinking a car accident occurred? I'm hung up on that. No car, 0 death of John by Karen.
Somebody,
Well,
at least
that's the
one
problem.
does.
Why, at
By
least
a
All,
one
all
process
has.
of
we're doing is
elimination.
speculating.
Yeah, somebody probably has to be thinking a car accident happened, because
Wouldn't
like
make
Mark
sense.
said,
Yeah.
if they're all in agreement that a car accident didn't happen, then she's not guilty on any of these charges. And that the rest of that's very simple. So somebody is hung up on there was some kind of an accident, and maybe they're arguing about, exactly what it was, and because that would go to her intent. You have to kind of know how it unfolded. But yeah, that seems to be the hang up. Did it happen at all?
I can see someone getting lost in the fluffy language. Not everyone gets it. Bev leaves a lot to be desired to her. Lazy and cranky. I would have clarified something before sending them back. Well, she can't really do that.
That's how they
because
do
she can't
it. And-
influence the jury.
Right. That's how the judge's language usually is. It's usually a very vague. We can't do that. You're stuck with what you got.
Mm-hmm.
Yeah. And to rely on
I'm
memory
envious
jurors
of
needed-
Mark here, hearing that in New York they'll even actually answer the legal questions. In
Yeah, that's
Washington,
impressive.
no, they won't.
Yeah.
They'll just say, refer back to your instructions. The defense
Oh, no.
attorney will beg them, here is the right answer, the right law. The judge will say, no,
You
I think I'm
will-
just going to tell them to read the instructions, and it's affirmed on appeal. It's discretionary. It's
You'll-
aggravating.
You get a note like this in New York, they'll call you back to the courtroom without the jury. The judge will say, how do you want me to deal with this? What does anyone have a view? And you ultimately can make an argument about what she should say or not. Ultimately, she'll say whatever she says, but it's pretty common that the judge will re-instruct the jury. They may have a question on intent versus reckless, and she'll answer it. They may want to can you give us reasonable doubt again? But again, they don't have the written instructions, and it can be a laborious process, but it's a better one because better you know what the judge is saying than two yahoos back there, neither one of whom may be very bright or arguing over what it means, and it's really none of the above, and they're just making words. You don't know.
And as Stephanie says, to rely on memory, juries need a speedy trial, not stretch over 2 months. It's absurd. It is absurd, but it's sadly what we got in this case, which should have been over in a couple of days. You're all overthinking this. Someone on jury is for McAlberts. If they let John O'Keefe die instead of getting help, they pay to protect themselves. But who got them on the jury?
I don't buy
Because
that.
they made sure that Yannetti and
Yeah.
Jackson
No way.
didn't strike them.
No way.
If
A
that
hung
is the
jury doesn't
case,
The
protect
odds
them.
are so
if
against
that is the case, y'all, the FBI is going to figure that out,
exactly.
and that person's going to go to prison too.
These guys aren't like John Gotti or Whitey Bulger. They don't have that much juice. I'm sorry.
No,
I don't think
and
that's
he
the
had to
case.
sell his house because he didn't have money for it or something too. So,
Yeah,
is it common
exactly.
for judges to
Yeah,
check in?
where's the money coming from? Exactly.
Is it common for the judge to check in with the jury twice a day? It seems different in comparison to other trials you watched. Well,
it's different. Yeah. I mean, again, going on a different state, but in New York, when you would go to like a second day of deliberations, they just go start deliberating. They don't even come to the courtroom and get told. And I can tell you the other thing, that the judge doesn't question them. Oh, do you want to go home at 3 o'clock? That strikes me as she wants to go home at 3
Yeah.
o'clock. The expectation is they work. Now, if they want to send a note and say, look, we're done, we're cooked, most judges will say, all right, that's fine. But I mean, she's leading them to say what she wants to hear.
we watched the trial from, I believe it was Florida, a guy who unalived his wife, and the judge actually said, well, you can keep going till I think the janitor is done by 11 tonight, and they'll just lock up when you go home. And you could just feel those jurors were, I think they were back at 8 something, because I had just gone to bed and fell asleep. I woke up and Jamie, my co-host, just, they're giving the verdict. I was sleeping through all of it. That was a little annoying, but he said, yeah, we're going to run it because they had some automatic system that would take out the light or something when the janitor left. He said, yeah, you're going to sit here all night. I would rather have that instead of Bev saying, oh, you're going to catch a bus.
Instead of
me
Bev
get out
trying
of
to
there.
catch happy hour.
I elect Val as foreman. Anyone who can't come to consensus get to step into the squared circle to voice their concerns.
You'll have a verdict.
Yeah.
Damn right they will.
A very fast verdict.
If someone is paid off and it's not discovered until after the verdict is reached, does that invalidate the verdict? It'll probably be brought up and
absolutely.
and
You
thrown out.
file a
Yes.
motion or an appeal depending on how it's found, and yes, you can have a verdict. Yes, that would be bad.
Any
That would
reason
be
the
very straightforward jury misconduct.
yeah,
Yes.
yeah.
any reason the jury would dress up more formally, usually indicating a verdict? We don't know.
Nope.
Again, it's
I
the
didn't
same with people who
understand
can
that.
they can tell you what the jury thinks because they saw them for 2 minutes in a courtroom.
It's just drama and speculation.
I
and
didn't
somebody trying to
understand
cash
that
in
on
the headline.
Friday. There was like a lot of discussion by people saying, like they're I mean, maybe they had plans to get the hell out of there at
Right.
Friday to go to dinner. I don't know, but I've never seen, in my experience, jurors who dress one way on verdict day come dressed differently, because today's the day we mete out justice. I maybe others, I don't know, Andrew, if you've ever seen that. I've never seen that.
That was the first time I've ever heard anything like
Yeah,
that.
me too.
Being a law nerd.
They
I've never heard that
claim
before.
in some, I think in the Murdoch case, they came back dressed nicely, but that was because they had interviews lined up with the press.
Yeah, the cameras, maybe.
Yeah. Does she have to give the dynamite charge if they come back hung again? Well, it's her discretion to determine if they have had enough time. And again,
thank
she
you for
has a history
clarifying
of sending them back 3 times before she reads it. So yeah. McAlbert's hardly bought off one jury, resulting in hung jury. They want. Oh, I read that one. They want him found guilty. Yes. Okay, this is a long trial. Nick is a little.
That's
He's
funny.
a little.
He's
feisty.
jaded.
He's so jaded. He's doing the YSL trial, which is gonna last at least probably a year. He's
decade.
He's
in
gonna
it
die
for the
before
long
that
haul.
case is done.
He's
Did you
been covering
see,
that trial forever since day one.
Jeez.
The witness's friend, the guy who played.
Yeah. Woody. So Woody's buddy, the guy that's been on the stand the last few days, Tay, apparently was ended last night in a firing of pew-pews.
I saw that.
And
I saw that. Yeah.
now there's a lot of speculation that Woody's gonna pass the buck on to Tay for a lot.
And
of
it was at Woody's house, wasn't it? At Woody's house
Yeah, his
that it
apartment,
happened.
I don't know that much of the details.
Yeah.
but that's,
I saw it
that
on
would be
Twitter.
impressive if that was the case.
And in the word, is the word morally in every jury instruction?
Morally?
I think
It was that instruction,
moral
the reasonable doubt. Yeah, the moral
God.
certainty language. I mean, I wish we
Crazy,
had
right?
that here. I love it.
How does anybody in Massachusetts get convicted of anything?
Well, no
That-
transcripts. That's the
that-
key.
well, there you go. Touche.
Idiot yourself out.
You hear that reasonable doubt definition and you say, my God, no one's getting convicted. Oh, we have our first
That
dog
was-
sighting, and it wasn't.
Yeah.
Me. Who is it? Look at that guy.
Oh.
Oh,
Do you suppose
Oh,
Lally had
baby.
someone hold the long darts to his mouth in his sleep over this weekend? I think Lally have been. Yeah,
Oh, God.
I volunteer for the Innocent Project because of this.
Nice.
Awesome.
If it's a hung jury, will we know the vote only if they want to tell you? Explain reasonable doubt, please.
It's a doubt for which you can explain a reason, meaning it's reasonable. It can't be just because you don't want to do it, so it's out of left field, you don't want to do it. Another way to think of it is, if you have a doubt that's reasonable, is it plausible? Does it make sense? Is that even a possibility? And if it's a reasonable possibility, then she should be not guilty, which is why when you go back to the ARCA thing, how is that possibly not at least a reasonable doubt, even if it's not proof beyond a reasonable doubt, but they don't have the burden of proof. And that's why the burden of proof is so important.
In non-lawyer speak, what he's trying to say is every defendant is innocent until the state proves that they're guilty. And until then, you have to have reasonable doubt.
Yeah,
Yep.
but you can't just say, "Well, I don't. I didn't like the way the
Yeah,
prosecutor."
she's got RBF.
looked."
She's probably guilty.
That's not reasonable. Exactly.
You have to say, "Well, there's this circumstantial evidence that the car never hit a person." That could be reasonable doubt.
To me, that's
what's
the
usually-
biggest. Like if the car didn't hit, if you have these people
Yeah.
saying the car didn't hit him and those injuries
That's
aren't
it.
consistent with being hitting a car, I don't care what the defense says happened. That means that something else reasonably. There's another reasonable explanation that this happened because this ain't it. To me, that would be the end of it. But
You could make an argument, and I've said this elsewhere, that under the rules of professional conduct, which I know Massachusetts is identical to New York, so I'm comfortable in saying this, that under Rule 3.8, which is the special responsibilities of a prosecutor, it is actually unethical to prosecute if you don't have probable cause. You could, which is a much less standard than reasonable doubt, you could make a credible argument that this prosecution is literally unethical since they have known about the ARCA reports. I would argue that's not even probable cause, let alone proof beyond a reasonable doubt, because if it didn't happen that way, it can't be.
This is bordering on, at the very least, malicious prosecution.
well, and
Yeah.
they
Very
said in
reasonable.
one of the pretrial hearings that what they say, like 90% of the
95
Fed stuff,
95% is the same as we had already seen.
which is crazy to me because it's
They
like
said-
So if
They
the
said there was
5% is the car never hit, then
it's
those
a big
5%
5%.
I was very late to the party, but I know when they were arguing over the TUI materials that I know Jackson was jumping up and down saying this is loaded with exculpatory evidence. And okay. And Lally was saying what you guys just said. It's like 98% the same. It's consistent. And there's maybe it was not Lally. It might have been the woman. I forget.
Yeah, it was the woman.
What's her name?
McLaughlin.
McLaughlin. Thank you. It might have been her. I don't remember who said that there's no exculpatory evidence. And then you find out the ARCA
She's a
report,
liar.
which I have to say, there is Brady material, and then there is smoking hot, holy crap, Brady material. The ARCA report is as exculpatory gets because it kneecaps their entire case in one sentence. The whole thing is gone.
Yeah. And note taking is a skill not everyone has in the heat of discussion. That's why I always drag my administrative assistant with me. Yeah.
You
that's
know what?
smart.
I need to take a second and talk to chat for one brief second. Chat, there is 4,700 of you roughly. We've only hit the like button 1,500 times. There's something wrong with that. If you've enjoyed this panel, which most of you clearly have because you've been here for the last 2 hours, hit the like button. It goes a long way in helping Baker grow his channel, spread the word that this is happening, and above all else, it's a benefit for Karen Reed to have voices of reason.
Hit like or Lucy
On her
goes to the
side.
pound.
Oh my God. How do I? God.
Just joking.
Are those Andrea's pet trained piranhas?
So these are metal art, fantastic pieces by my very good friend Heidi Elkington. Go follow her on Instagram. She is absolutely amazing. And these pieces are entitled Piranha Whales.
Nice.
And in that vein, as Valhalla just said, please like and subscribe. Val has to drink a beer every 10 minutes until Baker hits 10,000 subs.
Oh my God.
Let's protect our veterans.
Getting
folks.
wasted.
I'm gonna die. I'm gonna die.
Help them out. We don't want them to die.
Hypothetical, what happens if they come back with guilty with Crash Daddy saying it could not scientifically happen? I'm assuming immediate appeal.
Wow. They're going to appeal anyway if they lose.
Certainly,
Yes.
But
certainly.
Yes.
and Andrea will know this because I know you do a lot of appellate stuff as well. But disagreeing with the verdict is about out of 10, 1 out of 10, 10 and a half basis to have an appeal granted.
It's a negative basis.
Yeah, that's what I'm trying to say is as
Yeah.
crazy as it sounds, you'll need a legal basis, not that the jury was stupid, because that's not how it works. So
Yeah.
If you threw the glass at the taillight, wouldn't there be taillight in the street? There was, and I don't believe there was any. Yeah, there was. They found it next to the shoe, and then they found it again and again and again, somewhere.
Yeah. The
Don't
problem
think
is
about
still
it.
where's the rest of the glass? I
Yeah.
never got that answer. I was waiting to
so.
see
In the
where's the
house.
rest of the
Yeah.
glass, and they never found it.
Look in the house.
And it's bizarre to me because my instinct would have been, well, the plowing. Plowing is going to move all of the street detritus, to wherever. But strangely, the entire taillight is still there. So it can't have been that the plow moved the glass and just missed the taillight.
because taillight reveals itself.
Right.
The power of God. It
Maybe
just rises.
maybe glass just apparates out of the area, in
Ooh,
a
Harry
sudden
Potter
mysterious
reference.
fog.
Like people in a Sally port, for example. Right?
Exactly.
I have a bigger problem with that straw laying perfectly in the street because I don't know how you make straws in the U.S., but we make them out of plastic, and when snow melts, it will have floated away. Why is that perfectly situated there? It was so
Probably 'cause it was
very suspicious. Yeah, because can you put it here? Oh, picture, I found it. If she
Yeah.
really yelled, I hit him on the scene. Why wouldn't? I had that one detain her because she never did, because no one could really figure out when it happened. Both timeline doesn't make sense. She couldn't have hit him at 12:45, but why screaming on his voicemail 10 minutes after dropping him off? Well, that's the thing. Do you have a crack on that, Mike?
Yeah, I think because if you look at the initial, what she said, I believe, is that she was pulled up. He was going to go check it out and see what was going on, take a look inside, and give her like the okay, I'm all set. I have a ride home. Kind of look out the window. Open the door and say, I'm good. I'll see you later, honey. And he never came back out. So I think that might have been what was going on there.
Yeah, he just ignored her. I think you're right.
She had ignored her all day.
Yeah, I know, right? Read those texts.
Have you read the text?
Oh
Yeah.
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 She was basically his chauffeur.
Yeah,
I mean, he was being a jerk to her all day, and then when he needed a ride, when he got have a few beers, come pick me up. Like,
I think it's really interesting that like the ones that, and of course, they're not going to sit there and read them all, and I get that. But the ones that they handpicked, if you go back and actually read the whole thing, it shows such a different story of
Oh yeah.
what was
Right.
presented.
Yes.
Such a different story.
Yeah,
He
that's
comes
very
off
big.
as such a jerk throughout that entire text exchange.
and it doesn't mean he's a bad guy. It's
No,
just,
we've
No,
all
no.
been there,
No,
right? We've all.
But again,
been-
it's also a very different communication style. I would be like him, and she's one of those girls. When you say, "I don't want to talk right now," she thinks that means I should talk to you even more. And I would be just as him. I was just put my phone somewhere and I'll go somewhere else, and then we can argue about it when we see each other. I have the same personality as him. I don't,
Same.
if I say no, I mean no, and I just walk off.
if I'm in a fight with somebody, right? I just we'll put it off for now. I don't leave me alone. Once we get the opportunity to sit down and hash it out, we'll do that.
Yeah, and I think they have very different personalities. Jen
Yes.
finally got the number. Carrie Kate just pushed phone to her because Karen not able to look it up. Okay. Fall River reported that a Karen on the jury sees the holdout. So annoying. It's so obvious. Not guilty. Gee, great to see Andrea. Well, we don't know. And we can all claim it's because someone is on there who took math in second grade and really hated it. So the experts made them angry. It's just speculation. We don't know why. And it could be that 10 people are for guilty. We never know.
I don't think so. I really don't.
I don't
No,
think
no,
so.
no.
either.
But every,
Could
hypothetically,
just
be, but I
speculation.
don't think so.
Yeah.
no. SUV hit his arm while holding his glass that shatters, but does not lacerate his hand. No, because it flew up his sleeve and lacerated his arm, along with the rounded knobs on the taillight. That was so
dimples,
stupid when he
they
put
the
said.
dimples.
Yeah,
Dimples.
Oh my God, the
What
dimples.
an explanation.
Oh my
That
God.
was just, I felt insulted by that explanation.
Dimples.
Yeah, and say it within the last 10 minutes of his closing. He never asked anyone if it was consistent with the dimples. It was so. I would say it's those dimples line up perfectly with. Absolutely not. In no possible way does it line up with anything. Plus,
Excuse
it's
me,
inside
Baker.
of the
If
taillight.
you do this, it does. Okay.
Yeah.
How is
When-
it that he even said he was like he made sure that he showed the arm out and it was like, this is what you're saying, right? And then Lally said, oh, he never said that. Yes, he did.
Nobody ever said that.
Yes, he
Oh
did.
my God.
We have it on tape. We have these people.
I'm
Yeah,
getting a
that-
little more
that-
concerned for Lally's wife, if I'm being totally honest, because if he's gaslighting America, I can't imagine what he's doing to his wife.
Yeah.
Day
True.
5, Gallagher testified the taillight shattered when trying to remove it. He also said he's the one to call vanless and no reports. Oneness. Yeah. Who makes a report? Because you just.
Well, normally
In
or in this case.
Yeah.
Yeah.
Apparently, whoever feels like it in Massachusetts, like normally it's anybody who does anything material in the case, even if it's like a 2 sentences, you file the report, you make the report.
Yeah. But again, we are sitting here and thinking, why the F didn't they do? Where's the chain of custody on all the evidence? It doesn't matter. And we just have to go back to Bev is God in this courtroom. So even if they could say, but there's no chain of custody, which probably in most cases would have a judge say, yeah, that's weird. Nope, Bev allows it in.
I went back today and I watched Lieutenant Gallagher's testimony. And he didn't file his report. He was the actual individual that used the snowblower. Okay.
Mm-hmm.
He is the initial evidence collector. He didn't file his first report for a year.
Mm-hmm. And he
Yeah,
was the
and-
one that was like, he was the dude in charge of that before they swapped it over, and he didn't. Yeah, I was throwing things when he was
For a
talking about that.
year,
Yeah.
y'all.
It's unbelievable.
It's oh my God, it's so unbelievable.
Defense should have argued an alternative. State didn't exclude MVA that wasn't Karen's fault, i.e. John stepping into path of car or trip and fall.
This is the hindsight is 2020 thing. You can always second guess them. I for all that I have suggested areas where I might have differed in strategy from them, I am not saying they did it wrong. There's a lot of room for, difference in approaches on these types of things, and even people having different styles. They deliberately chose an all-in strategy on the framing. We have to think that they thought that through. They didn't just come up with that, because just on a whim or anything like that. They had clearly developed it in closing. They presented their case throughout with that in mind, or in opening, and then presented their case, throughout with that in mind. So it would have been a challenge then, I think, for them to shift gears and potentially go down that road, because that's the, from my perspective, least controversial part of it, the no car accident.
Yeah.
And I think they saw that too. Once you got through that crash reconstruction testimony, you saw the extremely poor explanation that Trooper Paul had given. It just, that seems like a pretty good basis to hang your defense on. So I just don't know that they necessarily had the room to do that, especially given the time constraints that they had to operate under. If they had another hour to be able to develop a lot of themes and get into more nuance and maybe address some of the instructions specifically, it might be a different question. But it's always difficult in hindsight, knowing how things unfolded to try to think of how it could have been different, but there's just no way they could have known that at the time.
Yeah.
And we've been going for a little over 2 hours now, and I'm sorry to all of you who have written all the questions. I had started a lot of them, but Mike has a show starting in 19 minutes, so you can go over and try and ask some of the same questions. I will be here running down all the super chats. I know Mike needs an out now. I don't know if Mark does the same, because he'll be with Mike in 18 minutes.
I can stick around for 10 minutes, and then I need to.
Yeah, we'll run it down. But Mike, thank you again so much.
Thank you so much for having me, Baker. I just my final message for everyone: keep your faith and just chill out. I'm quoted Bederow. Just chill, because Monday.
Everybody needs to chill.
Yeah, Monday.
Yeah.
I mean, we just gotta get to Monday. We'll see what happens. Thank you, everybody. I love you all. Thank you so much for letting me be on your panel.
Thank you for showing up, and we'll talk later.
See you.
Good night, everyone.
Bye.
Good night.
Bye.
Newton published Law of Motion 1687, Salem Witch Trials 1693. Karen Reed trial is physics with she's a witch. This is Monty Python
Fair.
level of science. Is she made of wood? How can we figure out? We can build a boat of her. That's on the same level. Over on Mike's channel, my dad saw Karen Reed headline on CNN yesterday and told me she sounds guilty. I lost my head. I told him I invested 8 weeks in watching the actual trial. Are you going to believe me or 30 seconds on CNN? Most people will say this, 30 seconds on CNN. Tail light pieces not at scene because the independent cop said it wasn't destroyed when he seized her car from Dad's house. That's, again, another thing that as in the jury room, I would be saying he clearly stated correct. And I hated that argument. She deleted the ring video showing where they looked at the broken tail light outside the house. No, you had two guys testifying for the state. No evidence of deleted ring videos. And they wanted to use that as an admission of guilt that she had deleted ring videos, even though they couldn't prove she deleted ring videos. She didn't have access to the ring videos.
Yeah, I would push back that there was not evidence of deleted ring videos. The issue is who deleted the ring videos. There was evidence that there was a 12:41 a.m. ring video of her arriving home that is now suddenly gone after it's already in the possession of Trooper Proctor and Trooper DeChico.
And
That's the thing.
library video that's not there. I mean, there's a pattern here, and I agree. There was a very strong argument to push back and say it doesn't exist because everything Proctor touches either disappears or shatters into 45 pieces.
Because the only thing that
reversed.
we know,
Or gets inverted, right.
Yeah.
Like the only ones that we know for a fact that had access to those ring videos are the police who were accessing it on his phone. When they did the forensics on the computer, and they're like, there's no login for any of that. There's none of that there.
Right.
There's no way to show that anybody else had access to it or logged into it. With the niece thinking during a pretrial documents or whatever said that when they talked to her, they thought that she said that she thought that Karen might have a password for it. But then when she testified, the reporters were saying that when she testified during the trial that she said that she didn't think she did. So that is the only suggestion that maybe she at one point had something, some kind of access to it. And the only ones that we know for sure that did are the police, who we know for a fact accessed it on his phone and were watching it, and now they're deleted. So I think it's crazy that they keep trying to say that that's Karen.
Sometimes when it walks like a duck and it quacks like a duck, it's a duck.
It might be a duck, yeah. But they did do that where they where they asked Ring, how long do you keep the records? And then they sent a request a week after they would have deleted it. So
Yeah,
you know nothing would show up, probably because some of you have been in the deletion box. They had to get all the evidence from Ring, and they had asked them before that, how long do you keep the records? And I think they said like 3 months or something. And then 3 months plus a week later, they sent a request for all the videos. It was so stupid.
Yeah.
Ed Wallace said, should have done direction of force on all pieces of light. It would tell them if it was broken inward or broken outward, like someone pulling them off. That would be a long, very dry testimony. I don't think that would have worked that well.
I think the problem with that too is, I saw what Ed and Ron, Duty Ron, had to say about the forensic failings in this case, and one of the big problems was the complete lack of documentation of nearly all of these taillight pieces, where they were located, and then even the ones that they did have documentation for was extremely bad. It just doesn't give you the type of precision that's going to allow you to do any kind of meaningful analysis from it.
No, and again, we used a commercial GPS that's 16 feet inaccurate. We didn't want to plot in all the numbers because it would just be one red blood. I couldn't do the math because it would underestimate the speed of the car.
We didn't want to place markers and then photograph the scene from a wide shot so you can see where everything relates to everything else, do that combination of the wide shot and the close in on the approach. I mean, in this day and age with digital photography, there's absolutely no excuse for not taking like 100 billion photographs instead of just the 5 photographs taken with some 1990s era potato that the Commonwealth did in this case.
No,
I would have to push back. It was snowing.
Stop it. Stop it right
That changes everything.
Stop it.
Guys, I'm going to jump off. I'm going to have to jump off.
Thank you so much for stopping by.
Appreciate it. Nice to
finally meet you, Mark.
Finally meet you. Yeah, no, I'm glad we had this. So I enjoyed it. Thank you.
Pleasure again.
Talk to you later. Bye. All-star panel, what a treat. Thank you for giving us your time, expertise, commentary, and energy. Well,
ooh, I'm the energy.
How much do you think maybe Karen's action and behavior? I read that one. They will have all the surprise witnesses evidence to prep for this time if a second round. Yeah. And they will be pulling up all the inconsistencies again and again and again. And you can't get a clean jury pool now because when we started covering this, I believe me, Brandi, Turtle Boy, and the LTL were the first, and Mike were the first people covering this. Then the Clara came up on board. We were maybe on a good stream, you could get like a couple of thousand views. Now there's at least 100,000 watching across all platforms every day. This case
has gotten huge.
This has the Streisand effect.
It's almost impossible to think that if this does end up going back to a retrial, that there wouldn't be some attempt to change venue just because of the absolute saturation, not just the media, but again, like what's going on down there at the courthouse. Surely most of the community is aware of this happening. It's just very hard to imagine being able to pick a panel that hasn't been influenced by all of that.
Arts
jury is not seeing anything or doing research. Low.
There's no way they haven't seen it, right? Like if you ever go on, so look at all the people outside of the courthouse. First of all, right? They understand that something huge is happening here. You can't get on social media, look at a newspaper, or even turn on the TV without at least seeing a headline. And you're like, oh, that headline has Karen Read in it. So you're going to read the whole headline, even if you immediately turn it off. There's no way they don't have some kind of information on how crazy this is.
Yeah.
And what happens if acquitted and then comes out they were? Does DJ still stand and can Commonwealth retry?
So that's actually a great question because it I don't know what the rule is in Massachusetts, but at least in terms of like the federal constitutional double jeopardy principles, no, the Commonwealth would get the benefit of the protections against jury misconduct just as much as the defendant would. There might be. Sometimes there's going to be nuance depending on whether it's something that the defense has participated in, like did they do something to influence the jury, and absent that, she may potentially get the benefit of the double jeopardy protections. But it's a great question, and it's probably going to depend to some extent on Massachusetts law.
Maybe Karen said they hit him. Someone asked what she said. Jen told them that Karen Reed said, I hit him. No, because no one heard her say that at the scene that morning. That was something that came out of the blue after Jen McCabe had been interrogated, and they sat at the kitchen table and said, oh my effing God, how do we spin our way out of this one? Then she called...
I think that's likely.
Yeah, because she called them back, and as I've said the entire time, I started to believe after seeing Brian Higgins, there was a fight. Accident happened. Chloe got on him, I don't know, bumped his head. And they thought, oh my God, let's get him out of here. It's snowing like crazy outside. It's 1:30. Brian, you go to the police station, get an alibi. We ditch him in the front lawn. The plow will take him. Or we can just claim he had a slip and fall. Because he was drunk and he was in the house and he had puked all over his pants. That didn't come up was really weird to me as well. But you could say, well, we had a slip and fall and he fell, and oh, so sad. And now all of a sudden she found him out there, and it didn't look like he was taken by a plow or anything, and they panicked, and then they had to put it on Karen. I think that's what happened. I think most likely Brian Higgins clubbed him in the face when he walked in, and then something kicked off because he was jealous. You could see that in those videos from the bar, but we'll never know.
I shared something, Baker. I don't care who you are. Those marks don't show up on your clothes if you're laying down on your back in the snow.
As somebody who has gotten punched in the face thousands and thousands and thousands of times, I have my own bloody shirt collection from the boxing ring. I am here to tell you, this is what happens. It drips down your front onto the front of your pants and onto your shoes. There is no conceivable explanation for why he should have blood on his shoes if he was not upright.
Perfectly.
No conceivable explanation.
Perfectly said, Andrea. Perfectly said.
Yeah, and get better friends if they punch you in the face that often.
They're wonderful friends. I love them. I love them with all of my heart. My friend Heidi, who does this art, she is a tiny slip of a girl, 100 pounds dripping wet, and one of the fiercest women that you will ever meet. She has bloodied me up so many times, and I love her for it. It makes me better.
I train MMA, jiu-jitsu. I'm with you, girl. I'm with you.
You get it. You get it.
Yes, ma'am.
No matter the verdict, if defense can prove that the judge that some of the evidence submitted was edited and tampered with, would there be any ramification?
Oh yeah, I mean potentially. Yeah, there's all kinds of due process implications, Brady implications with that type of conduct. Obviously ethical, above and beyond just the issues that would address the conviction itself. The question with things coming out after the fact always comes down to process, because the law very much prefers for kind of no matter what the verdict to be settled. They like things to be done and then just to be done, and to some extent even prioritizing things being done over things being right. So this would be a situation where that's not evidence that was presented at trial, so it's not something you can bring up in appeal process. You'd have to follow some other type of process, a motion for a new trial in Judge Bev's court, some kind of, if they have a habeas corpus type of process in the state court that allows you to present new evidence. Sometimes you would be able to do that, but I have absolutely no doubt if something like that came out that they could substantiate alteration of evidence Absolutely. They're raising this in every possible venue because that goes to the heart of the fairness of the prosecution.
Just a fact, Lunchbox said, I hit him 3 times in trial and 4 times in closing is proof of his BS inconsistency.
Yes. Yeah. I said that same thing too. As soon as he started that, I paused it and I was like, y'all, already the very first thing in his closing, he's got his facts
added
wrong.
one.
Again.
Yeah.
He said in his opening, and then Jim McCabe even said specifically 3 times. Everybody that said it 3 times. He said 3 times. And then he gets to closing and he adds on another one. And it's like for dramatic. Y'all, do you know how many times we've heard I hit him over and over throughout these last. So the fact that now all of a sudden you're just throwing an extra one in there just for fun, I was annoyed. I was
too.
That annoyed me almost as much as the fact that she's a murderer because she didn't take her dang shoes off. That was like that was a close second for me.
The expert didn't demo. No one demoed anything in Zachariah Anderson. 12 non-critical thinkers can't be on a jury. Free Zachariah Anderson. Yeah, that was a horrible closing as well.
Yeah.
I'm going to need a support group when this is over. If you watch the trial with 100% certainty that the Lexus didn't hit Officer John O'Keefe, it should scare the heck out of anyone. Well, welcome to the wonderful world of trial watching, where most of the time you will be sitting here saying, they didn't prove anything. She's clearly not guilty.
The jury got that one wrong for sure.
And you sit here after 2 weeks and you're just, I'm going to close my channel. I don't want to do this anymore. Because every time you're heartbroken, it's worse than breaking up with a girl sometimes, because you can just not see how any reasonable person could get to the conclusions they get to. And other times you have a Bradley yawn, and then you're just clapping when he gets life in prison.
That guy was horrible. Horrible human.
Could there be a private investigator watching the jury? I don't know. Maybe. I don't know what they would be looking for. To intimidate them, or that would be the worst thing if either side tried to intimidate the jury, because that would just let it all start over again.
I have to imagine that the FBI would figure that out at this point, and it would become public. So I don't see anybody taking that risk.
Any consequence for the DA's office for prosecuting this with the accident reports and the police for the investigation? Well, they did ask for a continuance, that Bev, and they didn't claim there was anything in it, and it's a mistake, and of course there's no consequences. Not before the feds roll in there. We had that one. If this ends up being a hung jury, what county do you believe would be best? Western Massachusetts, North Massachusetts, income and education are closer. In northern Massachusetts, race is closer in western. I have absolutely no idea about Massachusetts, other than I will never go there.
Yeah, Massachusetts and Wisconsin.
I don't know anything about Massachusetts either, but I'd probably be looking at press coverage. I'd be looking at the different areas and what coverage did they have in that area. It can vary quite a bit depending on where you are, even within a state. So that would probably be my focus, and just try to pick the least tainted possibility.
Guilty verdict tomorrow, but wrong. I hope not. That would break my heart again. Oh. They could be thinking insurance agency. You do not think agency for the FBI, CIA, maybe. Well, I do. Especially the way it was stated. I wish the defense had presented their closing in a similar way, like a checklist of the 5 absurd things that you need to believe to find Karen guilty. Well, everyone liked it. Well, almost everyone liked it when we saw it. It's because we are quarterbacking now.
Yeah.
And,
yeah. I liked it at the time. I think that Jackson's closing could have been stronger now, obviously.
And I can see in retrospect how to some extent it could come off as being, it's very attractive to those who already believe it. But in terms of speaking to the unpersuaded, maybe could have been better. But again, it's hindsight, and they had the time limitations. They had to make some very difficult priority decisions.
And hindsight is 20/20, and so is night vision also sometimes. In the Zachariah Anderson case, his daughter had 20/20 night vision. Why wasn't Baker hired as a court illustrator? Well, I did submit my explanation how it happened to to the court, I wasn't accepted.
So close. So close.
It's still better than
Trooper
what
Paul.
Levin did.
You're like right up there with microdots. Like honestly. I mean, like, don't give up your
It's
dreams.
close. Well, it's more accurate than what Plevin put out there.
Yikes.
You can't say it's a huge cover up and be quiet. If you do so, go for reasonable doubt. Yeah, always go for reasonable doubt. I know where the truly came from.
The truly in my fridge? Yeah, you do, probably. That makes sense.
Is the jury allowed to view evidence that is not shown in court? If it's
No.
not shown in court, it's not evidence. Well, you can watch the text
so if it
messages
was-
because... Yeah, go.
Yeah, if it was admitted but not published, like for example, portions of the video, the dash cam video, we only saw little select pieces of that. The text messages, another example, they only showed us select pieces of that, but they introduced a lot more as the exhibit. The jury can see everything that went in as an exhibit, including the stuff that was not specifically shown to them in the trial. They just can't see anything that wasn't actually admitted as evidence.
I don't know a single person that upgrades their phone for their birthday. Upgrades are always based on contact or breaks. Yeah, whenever your phone gets slow or it starts breaking, that's when you do it. The Arca guy said the tail light was broken by a small object because of the fragmented patterns. Do you think the juries remember that?
No.
Some might. It depends on how much they were concentrating on that, because I would probably have said, that's why I said I wouldn't have brought the glass into it, because then you were thinking about throwing the glass and, the cannon. I would just say it wasn't consistent with hitting a body.
But see,
And
that
that
small
was-
object thing makes me think of, like, if you're going for the defense's theory, like a small object could also be a hammer. If that kind of breaking is consistent with a small object hitting it, then that could also be a hammer or something else aside from the glass.
Or a
So,
baton.
yeah,
Like a Massachusetts State Trooper baton, possibly.
yeah.
Yeah, possibly.
Let's leave this case for a moment. What does the panel think the Fed case is investigating? Discuss. Thank you all. I think they are discussing investigating is the word. It's 2:30. I'm tired. Investigating the DA's office and the state police. This case isn't what got them in there. This is just the evidence they found is because they were already looking at the DA's office, is my opinion. Probably they had a shooting of a mentally challenged person that got shot. Was it 35 times or something like that?
Yeah,
and you had
Justin
the
Root.
Birchmore. Yeah, and you have the Birchmore. They probably had their eyes on them for that. And again, it's Massachusetts. It's not like they didn't have police problems before. That crime lab girl who had a meth lab at the crime lab, well, she had all the beakers and stuff. She could just as well use it. Any transcript across the entire trial made public available now or eventually, yeah, you could.
You could
probably
FOIA
pay-
it. You could pay the
Yeah,
court.
then you
for
have
it.
to pay for it.
Yeah, not FOIA. You just pay the court. Call
Yeah.
the court. You can print it out for you. It'll just cost a lot of money. Especially
It'll
this
cost a
long of a trial.
lot of
Mhm.
money.
30, 40 days in, this is going to be an expensive one to print out, yo.
Lally had a few lies in his closing. A lawyer's allowed to do that. Who keeps them accountable?
Closings and openings are not evidence. They're not factually based. They are a persuasive argument by the lawyers, and they can basically get away with saying anything they want.
And as
Yeah,
long
the
as no
burden
one
is on
objects,
the other side to object. If they think there's a problem that's been misstated, there needs to be a correction. They have to object.
nobody believes Brian Albert and his wife sleep with their phones in the bed. Nobody has ever had smacks with their spouse while their phone is lying with them.
Well, maybe
you
not
clearly
nobody.
never recorded anything for
How
OnlyFans.
boring. How boring is this guy?
That's why they kept calling. They had it on vibrate, and hey, when you get home, Hicken, call her all the time. Nope. I want Ed Norton to play Turtle Boy.
He'd be good for
Could
that.
do that.
Yeah,
Yeah.
he'd be good for that.
Who's the dude from the mayor of Kingstown? What's his name? He's also in the town.
The mayor of Kingstown?
Oh,
Yeah, the show Mayor
Hawkeye.
of Kingstown. He's mayor of Kingstown, and then he's in the show.
Jeremy
that's-
Renner.
Yeah,
Yeah,
is
Hawkeye.
that his name?
Yeah.
Yeah.
Oh, Yeah.
I could see that.
I could see that.
He got ate up by a snowplower or something, right? Like the track on a.
He's
he was-
perfect. He knows about snow.
Yeah,
What
yeah.
I
You had
would
like
like
a,
is I would
Go
like
ahead.
Harvey Keitel like 40 years ago would be perfect.
That'd be good. That'd be
Yeah.
good. That'd be good.
Do you think the children's testimony may have persuaded the jurors he didn't get a chance to hear what the kids said? We don't know because we only have Turtle Boy's words for what the kids said, and the girl apparently was worse than the boy, is what I gathered from it. But
they have like some of the other reporters that were in there. I went back and read all of the reporters that were in there for it. I went back and read all of theirs and kind of compared it and put it all together. And the most of them were pretty much the same. About I don't know that I can't remember what Turtle Boys said, but I know I went back and looked at pretty much all of them, and all of the stuff was pretty much the same about the things that they said. But a lot of it wasn't anything that was crazy, surprising, or shocking or anything. You know, a lot of it was like they were fighting more towards the end of their relationship, and they were, that Karen Reed used to like that she would do nice things for them and do things for them, but then if she was mad, then she would just kind of, like pout or ignore them, or just not talk and stuff like that. But it was nothing that was like really shocking on any of their stuff.
The typical end to a bad
you made the
relationship.
curtain even worse. Curtain goes behind the table. I'm sorry he's not here to see that. Question from Mike Crawford: how much of this case is this case the cork in the champagne bottle for local MA politics? Oh, I'm sorry I didn't bring it up while he was here. How do jurors commit to such a lengthy trial? I had a boss threaten to fire me for reporting to jury duty for 1 day.
That's illegal if they can't
That's
do that.
illegal.
No.
Yeah, that's illegal.
You'd got paid if they did it.
Question for panel: YSL witness versus Karen Reed witnesses. Who wins? The Karen Reed witnesses, because at least they could have been done in 2 weeks less if Lally didn't have gone back to Adam and Eve with every single witness. How if any many kids do you have?
Where did you
I
go to
have
school?
two, and it's a boy and a girl. Oh, thank you. I was just about to. What if any gender do they have?
Yeah. And where did you sit at the Canton High School girls basketball game when they lost in overtime to Foxborough? And like, what color?
Why was she
was
checking
your
the
toenail
score? She was at the
polish?
game.
Well, she said it was ozone basketball stuff that she was looking up.
Oh,
So it's like a different league.
Any
Whatever
thoughts
that-
on Jen McCabe being there? I thought it was disgusting to see them sit there, but
Yeah.
that's because I think they are. I think they have something to do with it.
Yep.
Juries get things wrong. Free Zachariah Anderson. Thank you.
Free Zachariah Anderson.
Have you all watched Truth Revealed channel's breakdown of testimony as a theory of how Brian Higgins killed John O'Keefe? Ultimately, he hit John O'Keefe with Jeep's tire iron and went to the office to switch tire irons with his truck. Wait a minute. I have to look that one up.
People have been tagging me in this all day, and I have not gotten out of bed. I literally did not get out of bed until it was time for this, and even then, it was only 15 minutes before. I have worked myself to death. So I was seeing people tagging me in this all day long, and apparently everybody's going crazy over it, but I have not had a chance to watch it yet.
I haven't watched it yet.
Nope, me
FBI
neither.
may have jury under surveillance to be sure. Probably not. It'll
Probably
take a
not the jury.
lot. Imagine every juror would have to have at least 2 agents on them. That's 14 people. That's 28 people. And they have to shift
Or one
3 times a day.
stingray.
One well-placed air tag could just handle the whole thing.
Just drone them. So happy to
Good.
see all my favorite hosts together. Shout out to Andrea. Positive Bev arguing with defense about jurors said the jury number doesn't count. It was the seat number which changed as juror was dismissed, not a lawyer, but made me go, what? I don't think she argued with the defense about it. She was talking to her clerk, and he didn't understand what she was talking about, is what I think.
When it boils down to it,
Yeah.
Bev's going to do whatever Bev wants to do because it's her courtroom.
Yeah.
And most of it is kind of just us picking at her. Otherwise, it's not really a big deal.
Well,
we should.
we should have a Viking drink off when I visit in August. And Andrea, I'm also visiting Delphi in August when you are there.
I'm not planning to be there until October. I am planning to go all in for the trial, so I'll be there for the 4 weeks or 6 weeks or whatever it is that she decided finally it was going to be.
Nick, when you get here, buddy, I'll build a giant bonfire, and we will drink and celebrate, sir.
Who are all these people? Do I have to behave?
Yes, you have to behave, Zach. Yes, you have to behave.
Okay. Can I still say racist jokes? Oh, good. Danes are the worst. Also, goat herders.
You have to behave, sir.
Even if she confessed it in normal police practice, if they investigate and realize he wasn't hit by a car, and then she confessed to the police to killing him with the car, they'll tell her, sure you did, and send her home. Yeah.
I doubt it.
But these people walked out of that house after talking to the McAlberts and said, it's her. And then they just went around to prove that. It was the other way around. I wondered about the lack of blood. Great panel. Well, thank you. A juror can refuse to deliberate any longer. I don't know if they can do that.
Well, that would be an intransigent juror. Again, this is an issue that kind of varies state by state, and so I don't know specifically what the rules are in Massachusetts. But there is, at least in theory, a possibility if a juror is not continuing to engage in deliberations, and there's not like a good reason for it, not a situation where like we've exhausted the conversation about the substance of the case, and we're just on different pages. If they're like shutting down, I'm not going to communicate anymore, that's arguably a breach of their oath. I mean, that's the duty that they undertook as jurors to deliberate fully and fairly and consider everybody's perspective with an open mind and so forth. So in some cases, a juror who just checks out can be found to be intransigent, and in that situation, they would replace them with an alternate. But that is a very, very fine line to walk. It does not happen very often, just because it can potentially be like a free issue on appeal, that finding of intransigence.
Have you ever seen that in your personal career?
No, not in my practice, no.
I've never seen it as a law nerd either.
They did it in Murdoch, I think.
Really?
Didn't they do it in Murdoch? They replaced one of the jurors, and then they found the juror had been intransigent.
When that went to financial crimes, I was done. I couldn't do it anymore.
Yeah.
Everybody's zoned out.
Spreadsheets in the middle of a murder trial isn't that fun. Please, everyone, stop super chatting. I'm trying to get to bed. Mike and Mark, please have truth revealed on the young Jurks, former intel officer exposed killer in Karen Reed case. It's a must-watch.
Truth revealed.
Yeah, that's what I'm saying.
Mike
People
is
have
still
been tagging
dual
it all
streaming,
day.
so.
Mm-hmm.
If Lally read the ARCA report, why didn't he change the theory to John through the glass at the taillight? Because Lally can't think on his feet. I advise all to listen to Stop, Look, Listen, Statistics, Styles P, Terminology, Q-tip. Okay. Did y'all all see Duty Run's Ed Wallace rant about the horrific evidence collection handling Epic? No, I didn't. Like Brandi, I've actually been sleeping a lot today. Sunday is my day off normally, so I was sleeping until 9 o'clock this evening. Will you all follow?
It and they pulled no punches.
Really?
Good.
Not a single punch did they pull on this investigation.
Well,
let's be real. The practices of collecting evidence in this case were absolutely horrific.
Yeah.
Disgusting.
Yeah.
Will you all follow the Birdsmore case, same cops, DA? Well, as far as I know, there's a civil suit against them that might involve at some point some criminal charges, but so far it's just a civil suit, a wrongful death, I believe it is. So, and
FBI has started looking into that one, though. I believe they, and then they had Dr. Bader had done a independent report and said that he believes it's homicide. So it may be, hopefully, going to get some ground going on that one.
Yeah, I think it was Wednesday we read about he determined it was a murder, not a self-deletion. Are jurors allowed to research generally about jury dynamics, how to deal with a rogue juror?
I would assume they can research that stuff on their own. Like there's not a standing order saying they can't, but you're flirting with jury nullification there, and the courts really frown on that. So,
Yeah. You're really you're walking a very fine line with something like that. With a technically am I like it's iffy.
Yeah.
The cops never thought Karen would not fight back, especially Proctor
Agreed.
hated Janetti and Karen
Yep.
because she did. Yeah,
Agreed.
and that's why they
100%.
upcharged her to force
Yep.
her to take a plea deal.
Yep.
But she had balls. 10 to 15 sound bites by Commonwealth witnesses on cross-defense testimony and in a reasonable doubt collage would be good. Yeah, if they were allowed to show it. I'm not because Bev asked them what they would be showing. Great panel. I'm optimistic. Free Karen Reed. In mid-2018, I switched from being a lib to being a huge MAGA who thinks the left is kind of wacky. But this panel reminds me that there are still sensible libs and we can see eye to eye. Well, I live in a socialist country, so...
Hey, for the record, I am very libertarian. I just leave me alone. Do what you want to do. I don't care what you're doing as long as it doesn't hurt anybody else. For the record.
What was dumber, the practice fighting or she kept her boots on? The boots.
Only
correction, Proctor never thought she would fight back. Exactly.
Mm-hmm.
You should literally get Baker to 10,000 right now. Subscribe. I watched the trial on this channel. Let's get him to 10,000.
Rubio.
No, because then I think I said I would get a tattoo when it reaches 10,000 or something like that. So probably shouldn't do that. I don't need more tattoos.
Can I draw your tattoo?
Nope.
Dang it.
Because the accident testimony is not possible by any known laws of physics. Yeah, that on that alone, I would have said, as a juror, I would just stand up and said, deuces, and walked out and said, not guilty. Anyone doing a deep dive into Sarah Birchmore? I don't know if... are you Brandi?
Yeah.
Of course.
Yeah.
And you know, when Brandi says deep dive, you will know her shoe size, her last meal, and what was in her fridge. You should be a PI for some. You are really good at finding all.
I hear that all the time. I need to be a PI or I need to be like a researcher for attorney or something. I'm a nosy thing. I'll find out stuff. I'll find out stuff.
I'm glad you're on my side. That's all I'm going to say.
I have my gym buddy. It's a girl. If she talks to anyone, her friend will have anything on them on their Facebook, their Snapchat. She'll have it all within 5 minutes. And says, how do you do that? I can't find friends I know on Snapchat.
Yeah. My friend started dating somebody recently, and she only knew his first name, and she showed me a picture, and I was like, give me an hour. And in an hour, I found his Facebook. I found his whole family's Facebook, their Instagram, his LinkedIn, pulled criminal records and stuff. Like, I mean, I was like, all right, you're good. But red
flag, run away. Danger, Will Robinson, danger.
I start digging.
Anyone out there, don't date Brandi.
Don't, it's a bad idea.
I asked this throughout the trial. When a coincidence is considered too many, PS, you are all awesome. Well, to us, before the trial started, but to the jury, sadly not yet. Judge said most recently, if you see something about this case in the media, put it out of your head rather than tell me immediately. That was odd to me.
Weird.
I think it's because they have all these, they on the overpasses and stuff like that, they have free Karen Reed signs and guilty Karen Reed. And so it's probably something like that. Not that one of them have been watching us tonight and thinking, oh, they make sense.
Well, at least we didn't title the video, "Hey Jurors, read this."
I'm going to change it. Andrea Burkhart and Mark Bederow, both practicing attorneys, want to influence the jury, just to get some clicks on it. Love listening to each of you, and brilliant to have you all on panel and all at once. Thank you so much. Yeah, I love these panel shows. It just take a long time. Rush to frame Karen, so internal affairs stay out. Could be. The lack of investigation were done on purpose. Same MSP investigation in Microdots. Good cop, bad cop show that they know how to investigate, to ask for neighbors ring cam, tape off crime scene. I don't understand that they just ask. Does anyone have something on ring cam instead of going to
Baker?
the
I don't know if you're aware of
spheres?
this or not, but Brian Albert's a cop. The guy that lives across the street, he's also a cop. So we're just gonna leave that alone. All right, we're gonna leave that alone.
Yeah. This was weaponized incompetence, no question about it.
Justice for John O'Keefe should have been the investigation.
Agreed.
It was fairly convincing when Lally quoted Karen Reed as saying, "Die, die, die."
Free Zachariah Anderson and get wrecked gravely.
Yeah, I loved he got a prison snitch in to say, well, in his sleep, he said he did it. Defense didn't make enough out of the bright lights on Lucky's Frankenplow. It could be.
Oh,
Valhalla,
I
keep
love
opening
Frankenplow.
those beers, dude.
I'm trying, man. I'm trying. I
Underrated
yelled at. I had
evidence.
to mute it.
Karen Reed's accidental recordings of Jen McCabe's unanswered call to her sis when she says, "Don't come out of the house, stupid windshield wipers make it difficult to hear." Yes.
Veilhammer Media did he reprocessed the sound. Go check him out. He's amazing. He's a wizard with sound, and he took out the windshield wipers.
Yeah. If Katie Bates isn't Dr. Russell, don't make the movie.
Oh, that's pretty good, actually.
If you get a chance, watch Trial 4 on Netflix. It really explains the corruption has been going on since the 90s.
That's good. Trial 4 is good. It'll make you
I
so
don't
mad.
I don't have Netflix anymore. Have you watched Your Honor? Displays how corrupt, regardless of intent, tends to be bigger and involve many others. There's a lot of shows out there that shows how the wheels of justice get greased up sometimes.
That's
With
a good
all the
one.
keep your voice up comments during the case, is it possible the jury couldn't hear many parts of the testimony?
Yes.
I thought about
Yes.
that too, and with them saying, that with holding the air conditioner
The
hostage
fan
and stuff, and,
hostage.
and saying that they're
Yeah.
going to, that they have to speak up. And there were, I can't remember who it was, but there was somebody where the jury even said, "I can't hear," and they had to turn it off for one of them. I can't remember who it was, but I've wondered about that too, about what they couldn't hear and what they were scared to say that they couldn't hear. If they missed anything, but we'll see.
They can almost hear. They think they can hear.
Yeah.
20 more subs to get 9,000 for your favorite Dutch, Scottish, Nigerian.
Oh, you're over that by a lot.
Yeah, and then 5 minutes later, he sends 9,000. Thanks, everyone. Show you my Lord face. I won't be drinking today because I'll have a stream tomorrow. Love, Brandi, the 13th juror.
She's amazing, ain't she?
Thank you.
I sent Max Murrow a picture of my grandpa's ashes. In 10 minutes, he told me what his must was in the army and his favorite brand of cigarettes. Terrifying. Yeah, Max Murrow is... Brandi is crazy, but, crazy.
Max Murrow was on a Lego stream with us last night, and he, by far, is the most terrifying person I've ever met on the internet. I love him to death. He's amazing. I've known him for a while, but he is scary when it comes to online information gathering. Shout out Max Murrow. Love you, bro.
What's your feeling about
you
Carrie?
won't.
Do you think Jen got to her? Is she naive? I actually didn't see much of her because I was sitting on a porch with some Yingling talking to a certain dreadlocked fella.
That
So
was
I don't know
definitely
about
when we were on vacation and the girls were covering for us.
Yeah,
But I
so
don't feel like she said anything that was which I think is the whole reason that they didn't even do a cross-examination on her, because she didn't really say anything that went against what we already knew or what they had said. I mean, most of the stuff that she said was pretty consistent with that. She didn't say that she heard I hit him, and she didn't say, honestly, the way that Jen McCabe was in shock and horror, talking about,
I was shocked.
the shock and horror. I was expecting, something to be a lot worse from her, but it was a lot of stuff that we had already kind of anticipated hearing. But I felt genuinely bad for her, because you could tell that when she was talking about it, and you could hear her crying when they were showing the stuff, like you can tell that, that John mattered to her, that was a friend.
The issue I saw with Carrie was that the problem with her testimony is that her memory was not reliable. And there's a lot of reasons why that can be. Not every time somebody gets the facts wrong means that they're lying. As Mr. Jackson pointed out so well with firefighter Natali, memory is a funny thing. I really wish he would have played on that a little bit more. Because there were specific things that Carrie said that Mr. Lally relied on consistently, both in his opening and in his closing. And a big one of those was that they lifted, they got there, they found John, he was covered in snow, and they lifted him up and it was bare ground underneath.
Yeah.
Yes.
We saw the photographs with our own eyes, again, with the gaslighting. Like, I'm not saying Carrie's gaslighting us, but the Commonwealth is gaslighting us because they know that version of events does not line up with the documented physical evidence of the scene. They specifically told us he had bled on top of the snow, so that's why they had to get the snowblower to be able to blow the snow away and follow the drips down until they could do the blood collection. So that was just one instance. Another instance, she had the same, coincidentally the same memory as Jen McCabe about going into the house at One Meadows Ave was when Karen showed them the broken taillight. She, unlike Jen, had the self-consciousness to recognize immediately after they watched that video that that's not what we saw, so I must have been wrong. So she acknowledged that. But these just, for better or for worse, without attributing any kind of malice to her or really anything at all, it just goes to show that her statement wasn't reliable. Her accounting of things wasn't reliable. And it is understandable, just given the stresses of the situation. She was close to this man. This would have been pretty traumatic. I would have liked that to have been played up a little bit more, because I do think there was the risk that, well, by not cross-examining her, you're just conceding that everything that she says is true, and then you're kind of handing the Commonwealth this ability to use her testimony as a weapon when it shouldn't. That should be available to you to point out, no, here's another reason why the whole timeline doesn't work, because look at the library video, look at the conditions on the ground. It was clearly bare ground. If we went down at that time, the ground would have been bare. Look at the photos from 7:30-ish or whenever it was at the scene, when they first documented where they took him. There is no grass available. He was on top of the snow.
Yeah, and that's so many things that you can. And the worst part, every time I go on next, someone is having a new. And I was just reading a theory about why the shoe fell off, and you're just sitting there thinking, oh, just get this case over, because people are really getting stupid. But well, thank you, Candace, for 5 gifted memberships, and Chrissy for becoming a member. Hope 8 Fear, new member. Hospice Jess for 5 gifted, and Miss Shanty became a member. Solomon's new member. Honey Reptilo, maybe a $5 super sticker, and Denise B super.
How'd you pronounce that name?
Denise B.
No. Connie what? Connie what?
Robledo.
That's perfect. That's so accurate. Oh my God, it's so good.
Mimsy for 1 Broken Baker membership. Friends, countrymen, Roman. I think I reached the end. So I can get some sleep before going again tomorrow.
Can I leave chat with one final thought? Actually, let's at the end, I'm going to leave chat with one final thought. Andrea Burkhart, tell the people who you are and what you're doing.
I'm Andrea Burkhart. I am on YouTube, Twitter, and Substack, occasionally doing random things on Instagram as well. I have been knee-deep in this trial since I think about day 8 was when I got sucked in and started streaming. So I am in this one to the end. I'm going to be waiting for the verdict, or for basically something material to happen in the case, probably sometime tomorrow. I'll go back live and cover that when it happens. Once we're done with Karen Reed, I'm going to be very likely looking at Alec Baldwin. As I've already indicated, further down the road in October, I plan to be in Delphi for the Richard Allen trial. There's not going to be cameras there. So I want to be on the ground to have a firsthand perspective of what is happening in the court, what the evidence is in that case, and so forth. I have been covering Brian Koberger from the time that he was arrested. So that one is, of course, ongoing. We have a trial date in about a year. So plenty of things to happen there.
They're calling that one a 3-month trial, right? They're saying that one's going to take 3 months?
Yes. They set it for 3 months. 2 weeks for jury selection, 8 weeks for guilt phase, and then 2 weeks for sentencing phase if needed.
Yikes.
So feel free to join me if any of those things sound attractive to you.
Hell yeah.
And Mimi
and
and
I'll
Honey.
be seeing you. I'll be seeing you, Mr. Valhalla,
Yes,
in
ma'am.
just a couple weeks here. And I have my Himeji Castle Lego build has arrived. I'm a little intimidated by it, so I might get a little head start.
July 27th, y'all. July 27th. Brandi
Yes.
has done the Lego
Here's my
stream.
Lego
and built
stream.
The beautiful orchid
I
set.
love it.
This was my
It's
Lego
Beautiful.
stream.
It's good.
And you can read all the text messages on my Discord. If you're links in the member tab, if you're not a member, reach out to one of my my moderators. They will get you a link.
Not me. Don't reach out to me. I'm not giving you shit. Brandi, tell us who you are and
No,
what you're doing.
no.
My bad.
I will just
my bad.
first. I will just first not read this one. Then Brandi can go.
Valhalla's the worst mod ever, and you keep trying to get a wrench on my channel, and you're
Listen.
like, I'm not doing nothing.
I promise you one thing, that I will not create problems as a mod.
Well, there you go.
Yes.
I am also on YouTube. I have my YouTube channel, and then I have my podcast, 13 Juror Podcast, that I'm very, very proud of. And I've been doing a deep dive on this Karen Reed case since last year, like the end of last summer, I think is about when it started. So all of the information I stream it during the day, but then all of the information that I take and put together, then I kind of try to make it a little bit more digestible and understandable and break it down in the podcast. So that's like Apple and Spotify and anywhere. And then I'm also on Twitter, and I don't read Twitter a whole lot anymore because trolls are out of control, but I'm there and I'm posting, and so I put some of my stuff about this case on there too.
And Amy's positive pathways. You see some people saying they believe Karen is guilty based on earlier interviews, but the jury is not supposed to know anything. No, it's not presented in court. Ergo, they can't consider that as a part of their deliberation. Valhalla, what are you doing?
Well, sir, starting tomorrow, we're going to continue jury deliberations on both of our channels. So that's the thing. I've started a new stream today about art with a Dictionary Diva. And the final thought that I was planning on leaving you with, but he called me instead of him, was mediocre watercolor is better than mediocre chicken parm every day of the week. And in addition to Andrea on the 27th of July, we have a Lego stream on the 20th of July with Cope and Seethe. So that'll be fun. In the meantime, I'm going to be doing the deliberations with Baker.
Yeah. So until tomorrow, 10:30.
And bitching about how I'm not at the pool every day.
I know. I want to be outside so bad. I'm
My
like,
daughter-
because I said I was going to take a 2-week vacation when this is over. Because between the podcast and the streaming, like I am a zombie at this point. And so I keep saying like, and I thought we were gonna have a verdict. So I was like, I was telling my friends, I was like, y'all make plans, we're getting wild. Like wild for me is like, 10 p.m. But still, I was like even I don't know if you can see my dish rag back here. It said born to be wild, but only till like 10 p.m. or something like that, or 9 p.m. But I told my friends, I was like, 2 weeks off, we're going to be at the beach and the pool and doing all this, and I have not left my computer. It has not happened. So I'm ready though. I'm ready for a verdict and to move on with our lives.
Yes, ma'am.
Yeah, my daughter's coming to town tomorrow to get another tattoo, and I was supposed to go out and have fun with her, and I had to say, well, they can't get done, so I'll just show up at the tattoo shop and say hi and give you some money so you can go out and eat. And well, she's getting an Elvis quote because her dad's an Elvis lover. So, daddy's little girl. But Besides that, we'll be back tomorrow at roughly 8:45, 8:50. Valhalla will complain about the heat, the lack of pool.
Well, yes,
I will complain about something else. And if you're not... don't put that
Finish your
behind the
sentence. Stop talking. Oh my God.
Well, now I'm going to drag it out. And if you're not watching it with us, you should watch it with one of these two ladies. They are absolutely amazing. And if you need the recap of the show, you should go listen to Brandi's podcast. It's absolutely filled with all the facts you need. And now I have to leave because Valhalla is crying because he needs to pee that much. Thank you so much for joining us tonight. And thank you, Andrea, for the first, hopefully not the last. And Brandi, thank you again for showing up. And the rest of you, go out there and have some fun. Show everyone their links are in the chat. Show them some love and hasta la taco, as we say.
What exhibit are you referring to? I'm going to make this 100, Your Honor. 100.
100.
Because it is
100%.
correct.
Objection, Your Honor. So you literally built a cannon?
Yeah, it's pretty awesome.
Go
All right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.